Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Stack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello, my friends, and happy Easter, everyone. To everyone who celebrates Easter. Today is Sunday, April 20th, 2025, and we are less than 48 hours away from opening day. Opening day, season 2, the sequel to the Karen Reed, Michigas, Fakakta, Persecution out of Norfolk County, Massachusetts. It's hard to believe that we are less than 48 hours away. And it's also the last day of Passover, and happy Passover to everyone who celebrates. And also for all of my friends who celebrate 420. Today is also 420. When Easter and 420 and Passover all collide. I don't remember the last time that ever happened, if ever. When, if ever, that ever happened. The Goodmans are here, and they've already gifted a membership, and they're spending their holiday with us, everyone. So yay to the Goodmans. And Brian's mom. Hi, Brian's mom. Thank you for joining us today. We're going to keep it clean because it is a blessed day in so many of the religions. Zimmy, thanks for becoming a member. On top, thanks for being on top of your super sticker so early in the stream. Thank you so very much. And the Goodmans gifted a membership as well. So they also gifted a membership, and they said that their mom is here too. And happy Easter. Happy Easter. Happy Passover. Happy 420. It's a big day in Boulder today. It is a big holiday in Boulder. Sco Buffs. How's everybody doing? And it's your birthday. It's Pam's birthday. Happy birthday, Pam. Happy birthday, Pam. We have things to catch up on today. Happy Resurrection Day. And we have something. 420 is International Pot Time. I don't know why. It just is. If anybody knows how that came to be, you can let me know. But Reefer Madness and all that kind of stuff. Thanks, Kel, for being an amazing person, moderator. And being with me for 18 months, an OG. And Midnight Mike is here. Changed his name back to Midnight Mike and also gifted a membership because you guys are so awesome. As is M. Monge, 1967. Nothing to see here with her super sticker for the holiday. Okay, here's what we're going to do. I'm going to tell you what we're going to do. And then we're going to do it. And then we may get sidetracked along the way, as often we do. Go off on tangents and such things. And then afterwards, I'm going to tell you what we did. I've learned that from our new friend, New York attorney, newest member, well, not the newest member of the defense team, Bobby Alessi. We also call him Scissor Hands because he's going to be able to single-handedly slice apart any witness, expert witness, that Hank Brennan chooses to call and put on the stand. It's going to be fantastic. It's one of the things that I'm looking forward to the most. Just one of the many things. So you may remember that we did have a hearing in this case. When was the last hearing already? Today's Sunday, right? The final hearing and motions was, I have to look at my calendar. The 15th, right? Which was Tuesday. Or did we come back on? Yeah, it was Tuesday, right? I don't even remember at this point. But what had happened was at that motions hearing, Hank Brennan got up and said that he was going to, he wants to call an independent reader to read the text messages into the record of Karen Reed and John O'Keefe. And defense got up and was like, huh, what? Why do we need to do that? We don't need an independent reader. Trooper Garino read him into the record last time, and he did a fine job. And the problem with having a reader is that sometimes the reader will use certain inflections, put certain intonation, add tone, feeling, and other things that you just don't want in a court proceeding. And typically it is done by the witness, like Garino, who found these text messages, actually, unlike in the Sandra Birchmore case, if you know, you know. And Garino read them into the record, very monotone, and that's the way it's supposed to be done. But Brennan says he wants to bring in an independent reader, I don't know, at a central casting or something, to read the messages into the record whenever he feels like it throughout the trial. Some of you may have seen that we went on Nurse Kim's channel. Was it last night or only last night? Claire and I went on Nurse Kim's channel, and we challenged Nurse Kim and Auntie Deb to a read off. We read the messages between Higgins and Karen Reed last night. Will and I went first, and then the big reveal when Auntie Deb and Nurse Kim did their. It was funny. We were trying to add a little humor into this because those of you who watch the Karen Reed case consistently know how draining and emotionally taxing it can be. So every now and then we try to, add a little comedy. It was a fundraiser for the Karen Reed Defense Fund, and it was a lot of fun. Did you guys see it? Will and I, on his show one time, a long time ago, did the Karen Reed and John O'Keefe text messages from the day of January 28th, and it was very interesting. Very interesting. And those are the messages that the Garino read on the stand, and those are also the messages that Brennan now wants to bring in an independent reader for. And when the defense got up and objected to it, Canoni said, yeah, put that in writing, and I'll think about it. Put it in writing by close of business Friday, because the defense team had nothing better to do in their preparation for opening statements this coming Tuesday than to have to respond to this ridiculousness in writing. And so they did. And we have an 8-page opposition to the Commonwealth's request for use of independent readers. Let's take a look. Let's take a look. This is docket number 679, which was filed on the 18th, which was Friday. That was the due date, a little after 4 p.m. I'm surprised there was somebody actually in the courthouse after 4 p.m. to stamp this and get it into the record, but they did. And here's the opposition. Defendant's opposition to the Commonwealth's request for use of independent readers. Here comes the defendant, Karen Reed. Ms. Reed, in response to this court's request for her written objection in response to the Commonwealth's request to use independent readers with regard to purported text messages exchanged between John O'Keefe and Karen Reed. The Commonwealth has not filed a specific motion nor provided any legal authority related to this request, but recently expressed its intention to use independent readers to present electronic communications between Ms. Reed and John O'Keefe. Mr. O'Keefe, yes, that's true. And is anyone surprised? No. No, Commonwealth just says they're going to do it, and so they think they should be allowed to do it. They don't make motions. They don't cite any authority. They don't put any case law into their requests. They just do it. Background. On October 14th, 2025, for the first time in less than 10 days before the start of the trial, the Commonwealth first introduced the idea of utilizing an independent reader, stating that it, quote, moves to provide notice that it intends to introduce the defendant's own statements without a witness or in some circumstances through a non-percipient witness reader, citing the Commonwealth's notice of intention to introduce extrajudicial statements of the defendant at page 2. We went over that notice in a previous stream. Most of my streams, almost all of them, I think, are time-stamped, so you can find exactly what you're looking for without having to scroll through the entire 4, 5, 6 hours or however long it takes us to get through it that day. The Commonwealth's request was limited to a single vague sentence without any supporting legal authority and was not made until long after this court's deadline for the filing of motions in limine, or we call them motions in lemonade because that's what the closed captions called them one day. Attorney Brennan again discussed the idea of using independent readers during the April 16th motion hearing, more specifically detailing the Commonwealth's desire to use independent readers to present various electronic communications between Ms. Reed and Mr. O'Keefe. The defense quickly objected to this inappropriate theater, especially given the high probability that such a staged delivery could be unduly prejudicial against Ms. Reed. Footnote number 1, which reads, although Attorney Brennan stated that, quote, there would be no inflection that would be inappropriate, end quote, the defense does not feel it's prudent to take that risk. Or does feel it is prudent to take that risk. I'm not sure what maybe not is missing. If a jury were to hear these messages read inaccurately, no sustained objection or striking from the record would successfully undo that damage. And it's true. You can't unring a bell, right? You can't unring a bell. And letting Brennan get up there and call in God knows who, Alec Baldwin and Amber Heard, to read the text messages might be just a little more prejudicial than having Trooper Garino read them, right? Notably, at no point in its writings or oral arguments has the Commonwealth provided any legal authority or basis for its desired use of independent readers in this context, namely for the reading of text messages. And as I explained to you guys, I think it was, yesterday, the day before, what is typically normally done in cases like this is that an attorney will take the stand. For example, Ms. McLaughlin could take the stand and read Karen Reed's part, while Mr. Lally could read John O'Keefe's part, because attorneys know how it's supposed to be done. They know not to, put any feeling into it or any motivation into it or any tone into it. Or sometimes they use a legal secretary from the office or a law clerk, and that's typically how it's done. Argument. 1, electronic communications should be introduced in accordance with standard procedure. Boy, have I been screaming about this for a long time into my closet and at and with you. In June of 2024, during the first trial of the above captioned matter, electronic communications between Ms. Reed and Mr. O'Keefe were introduced as evidence through the testimony of Massachusetts State Police Trooper Nick Garino. Trooper Garino, we call him Trooperino. During his testimony, Trooperino authenticated the messages between Ms. Reed and Mr. O'Keefe and read them into the record. This method of introducing electronic communications is entirely consistent with standard procedures in Massachusetts. See Massachusetts Rule of Evidence 901, detailing requirements for authenticating electronic communications. Citing another case detailing testimony of authenticating state trooper reading aloud messages between defendant and victim. Footnote 2 reads, furthermore, Massachusetts courts have emphasized the importance of authenticating text messages before admitting them into evidence. See Commonwealth v. Alden. It is unclear how the timing of the Commonwealth's proposed use of independent readers would comport with this requirement. Conversely, the Commonwealth has not provided any statutory authority, case law, procedural rules, or evidentiary rules that would support its suggested use of independent readers for the purpose of performing the electronic communications between a defendant and a deceased party. Footnote 3. Even though the Commonwealth failed to provide any supportive authority for its position, defense counsel made its best efforts to find any examples of this scenario in Massachusetts case law, but to date has not identified any examples that would support the proposition that communications between a defendant and a deceased party should be introduced by way of independent readers, which is basically a little dig saying, even though you didn't cite any case law, we went out there to see if it existed. We did your job for you, Brennan. And it doesn't exist. There's nothing to support your position. The defendant strongly opposes the use of independent readers and favors the standard evidentiary and procedural methods for introducing this evidence. Roman 2, independent readers are an inappropriate way to convey electronic communications. Use of independent readers to introduce electronic communications, such as text messages, is per se improper. Text messages are not verbal conversations. They are written communications which speak for themselves. The theater of utilizing multiple individuals to perform a text message conversation is not an accurate reflection of a text message conversation, even under the best circumstances, and putting aside concerns regarding tone, tenor, and timing. The Commonwealth's proposed use of independent readers seeks to create evidence that never existed. Well done, well done. With regard to text message exchanges, such as those between Ms. Reed and Mr. O'Keefe, there was never a live conversation, yet the Commonwealth seeks to create one through its use of independent readers. This is manifestly prejudicial and a due process violation. Traditionally, readers are used to reenact prior testimony that is unavailable to the jury, such as prior testimony of a deceased witness. See Commonwealth versus DiPietro, Massachusetts case. Prior testimony of an unavailable witness may be introduced by means other than an official transcript. In those circumstances, readers serve to provide the jury with a facsimile of what they would have heard had the witnesses been available. That is not the situation at issue here, where the Commonwealth seeks to have independent readers reenact text messages as a verbal conversation that never took place. That is such a great argument. The best practice would be to present jurors with the texts and allow them to read them themselves, but short of that, the common practice of having the text messages read into the record by way of the authenticating witness, Trooperino, is sufficient. Overall, the defendant strongly opposes the Commonwealth's proposed use of independent readers to improperly reenact text messages that were never verbal conversations in the first place. That said, tone, tenor, and timing add another layer of concern. Tone and tenor of written messages is subjective and individualized. As such, presenting a written conversation as a verbal conversation is an inherently problematic way to convey this type of exchange. Presenting text messages by way of the neutral reading of an authenticating witness, often with the visual aid of screenshots of the messages themselves, which is what Trooperino did in trial number 1, is the most logical and neutral way to present those communications. With regard to timing, text messages are not always sent in real time. Often, and specifically in the messages at issue here, minutes or hours pass between messages. There is no practical way to present these delays accurately. With multiple independent readers, as we assume the Commonwealth does not intend to make the jury sit for multiple hours between the reading of messages. Most importantly, we do not have to wonder if the authenticating witness of the messages would be capable of delivering these messages appropriately. As discussed by Attorney Jackson at the April 16th motion hearing and reiterated here, Trooper Garino's delivery in the first trial was perfectly adequate. It stands to reason his delivery in the second trial would once again be perfectly adequate. And also, it's going to be some great cross-examination because, so much has happened since the last trial with regard to Trooperino's role, let's say, in the Sandra Birchmore investigation. 3. Independent readers presenting text messages violates fundamental rules of evidence and procedure. A. Use of independent readers to introduce text messages violates the best evidence rule. I've been screaming about the best evidence rule. That's the part I meant to say that I've been screaming about for a long, 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 long time. Takes me all the way back to evidence class in law school. Those of you who are lawyers, you might know about the best evidence rule too. And we're going to tell you what the best evidence rule is because it's in the papers. The Commonwealth's proposed use of independent readers to introduce text messages would also violate the fundamental principles underlying the best evidence rule. The best evidence rule requires that to provide the contents of a writing, recording, or photograph, the original must be produced, or a sufficient excuse for its non-production must be provided. Specifically, oral testimony designed to prove the contents of an electronic records, such as text messages, is barred for the same reasons as those underlying the best evidence rule. Can you say metadata? Additionally, for the purposes of authentication, courts often rely on individuals with direct knowledge of the digital evidence, including the police officers who extracted the messages. This strongly aligns with the underlying principle of the best evidence rule that the proponent of the evidence must provide a foundation sufficient for a reasonable jury to find that the evidence is what it purports to be. I'm going to give you an example of that right now. I'm going to break from this document to say when the foundation was laid by the Commonwealth, Adam Lally himself, with Yuri Buchanan on the stand, Trooper Yuri Buchanan on the stand, when Adam Lally put up an inverted video of the Sally Port on January 29th of 2022, he attempted to lay the foundation for that video by saying to Trooper Buchanan, "Is this a fair and accurate representation of the Sally Port interior on January 29th of 2022?" To which Trooper Buchanan said yes. And then that lays the foundation, authenticates the video, and then Trooper Buchanan was questioned more and more and more about the video. Now, it wasn't until cross-examination that Buchanan was asked something like, I'm going to paraphrase here. This is the improv. Trooper Buchanan, isn't this video backwards? Isn't it flipped or mirrored? Oh, yeah. Well, yeah. But on direct examination, Trooper Buchanan, didn't you say that this was a fair and accurate representation of the way the Sally Port looked on January 29th, 2022? Well, yeah, it's like mirrored. It's like, like you're looking in a mirror and, everything that you see in the mirror is like there, but it's, just like inverted. Right then and there, a mistrial should have been called, and something happened at sidebar. We don't know because all the sidebar conversations are sealed. And that was what I consider to be the Commonwealth perpetrating a fraud on the court. There were no grave concerns, though, by the judge at that time. No grave concerns at all. Moving on. Here, the Commonwealth proposes that independent readers present text messages instead of the readily available Trooper Garino, who is the primary proponent and authenticator of the text messages at issue. As such, we oppose this use of independent readers as not only unnecessary and prejudicial, but also as violative of the best evidence rule. B. Continuous presentation of text messages by independent readers is unnecessary and potentially procedurally unsound. Lastly, at the hearing on April 16th, Attorney Brennan asserted, so that we had a hearing, I guess that was Wednesday that we had a hearing. Okay, Wednesday. Attorney Brennan asserted that it is not sufficient to simply have a state police officer who is not a witness to those text messages come in and read them continuously through the trial. Okay, so that's what Brennan said at the hearing. You remember that. He said, it's not sufficient to simply have a state police officer who's not a witness to those text messages come in and read them continuously through the trial. As described in detail throughout this motion, we firmly disagree that it is not sufficient to have an authenticating state police officer present text message communications in a trial. Beyond that, though, Attorney Brennan's suggestion that these messages come in continuously throughout the trial and at different parts of the trial when they become relevant does not appear to be practical or procedurally sound. Footnote 4. Additionally, where text messages have been admitted into evidence, there is no need or purpose for their repeated reading to the jury, as they will have ample time to review these communications along with other evidence during deliberations, and counsel may reference them by citing to the record. Given the Commonwealth's failure to provide any legal foundation for utilizing independent readers, it is difficult to know how they intend to introduce text messages continuously and when they become relevant. Footnote 5. Regarding Trooper Garino specifically, during the April 16th hearing, Attorney Brennan suggested that bringing Trooper Garino back repeatedly would create the wrong impression. Given that Trooper Garino was able to introduce the exact same messages with ease during his continuous days of testimony in the first trial, we remain confused by the Commonwealth's concerns. Well, I think we're all confused. Regardless of procedural underpinnings, Ms. Reed opposes the idea of continuous introduction of messages in general, as it sounds bulky, inefficient, and unduly prejudicial. Conclusion: for the readings set forth herein, the defendant respectfully requests that this honorable court prohibit the use of independent readers in her trial. And there you go. I think that's a great opposition. Garino did it the first time. Why can't he do it the second time? They're going to get them in evidence. The jury can read them themselves when they're back in the jury room. And the only time, apparently, in Massachusetts that independent readers are used is when it's prior testimony. And one of the people who previously testified is deceased. That's what they seem to be saying here. The Commonwealth is confused. They are super confused. They are all very, very, very confused. Thank you on top for your compliment and your super sticker. Pretty and blue is every color. Thank you. Watching the OnlyFan. Thanks for tuning in. If Brennan wants them read, have Lally and McLaughlin read them. At least that gives them something to do but stare at the judge's desk. Yeah, but I think what they're saying here is that under the case law, that would even be improper because Garino's the one who found him. He authenticated him. He read him last time. This isn't prior testimony. This is electronic communications. These are text messages. It's not a conversation, which is a great argument because text messages haven't been around forever. This is a new area of the law, right? But again, even that would be better than an independent reader. Laura, thanks, Laura Riker, for coming in. The 420 term and its association with cannabis originated in 1971 with 5 high school students in San Rafael, California, known as the Waldos. They used it as a code to designate 4:20 p.m. Thank you, Laura, for your knowledge and for laying your knowledge on us as well as your 10th spot. Christine Mitchell, thank goodness you're on tonight, Mel. My husband is away and I feel better now you're on live. Oh, thank you, Christine. I'm so glad to keep you company. Samuel Brinkley became a member. Welcome. Blue Varo. Thanks for your super chat. They need to bring in Ben Stein to read the text messages. Yeah. Or Ben Stiller. I'd allow that. Pineywood's Long Crime. Thanks for tuning in and for your 20. Hello to all my favorite cupcakes and especially dear Melanie. My surgical recovery. My surgical heart. Oh, your heart's is moving right along. Maybe I'll be up to flying to Boston for the closings. Thank you, Melanie. And he has risen. Thank you. And I'm so glad that you are doing well. We are sending you all of the healing vibes. And so glad we can keep you company during your recovery. Send all the healing vibes to Piney Woods. Karen Sutter, welcome. Became a member. Melissa Dulac, does Brennan want to use the readers so he doesn't have to call Chuparino? Maybe. Because remember what he said when he got on the stand. Wait, there's so many people that are new to this case that I think I need to play it. I think I'm going to play it. Thanks, Melissa. On top, Chuparino will be a Bigfoot research after this. Yeah. You know what? I'm going to play it because, we have this amazing new resource. It's called the Trial Channel on YouTube. Shout out to the Trial Channel for parsing all of the testimony down into individual videos for each and every witness. I was watching it before. Hang on, because I'm going to play it for you. And we're going to play a little bit of him reading the text messages just so you can see how dry he is when he reads them. All right, hang on. Might as well. Let's watch a little Chuparino, eh? So many people are new to this case. How many of you in the chat are going to be watching trial 2? Well, we're all watching trial 2 for the first time. How many of you are going to be watching trial 2 that did not watch trial 1? If that is you, put a 2 in the chat, meaning you're only going to watch trial 2. You didn't watch trial 1. And if you also watched trial 1, put a 1 in the chat. And you're also going to watch trial 2. So 1 if you watched trial 1, and a 2. Look at Kimberly is here. She didn't watch trial 1. She's only watching. There's a lot of new viewers, which is why I feel like we need to start somewhat at the beginning because so many of you are not you don't know all the lore. You don't know the lore. We're going to look at some lore after this. And so, because I want you to go into trial 2 knowing the lore of what happened even before trial 1 and how sus so many of these witnesses are and how many of them changed the patty, how many of them changed their stories 100 times. And all of those things are reasonable doubt. Sham Wow is here from Canada and says, I filed this motion to the court to request the addition of a song by Whitesnake. Here I Go Again. Is that not on the list, ShamWow? I'll allow it. Here I go again. I thought, because I was listening to that the other night, Whitesnake. I mean, who did not want to be Tawny Katane on the hood of Whitesnake's car? Anyone? Did anyone not want to be Tawny Katane? And then, poor Tawny Katane, she had a rough life. Anybody get my reference? Does anybody know who Tawny Katane is? Also requested that Beautiful Day by U2 be held on ice until acquittal of this sham. Yeah, that is in there. Only because Karen's favorite band is U2, and that's why it's in there. Also, what I also put in there is the song that we became introduced to the other day by Derek Carney, the How Dare You song. That is on Spotify. It's on the playlist now. For those of you who don't know, now you know. We have a Spotify playlist for the first Karen retrial. It is in the show notes below. You can save it on Spotify and you can listen to it at your leisure and put it on a really, really high volume. Julio said, my friend had a shirt that said 419. Got a minute? Oh, that's hilarious. That's hilarious. Bev's Straw Hat Hair is here with a super sticker. Thank you, love. And Talk Time with Amy in Boston is here and for 16 months, although she's been here since day one. I love you too. I love you more, Amy. I love you more. I love you most. Love you the most. There's no evidence. How dare you? Yeah, isn't that awesome? Love that song. Okay. Let's watch a little bit of Trooperino, shall we? Once again, shout out to The Trial Channel. You can find them on YouTube. They have parsed out not just the Karen Reed trial, but many, many trials. And you can get each witness individually wrapped. Let's listen to him read a little bit of Karen and John's text messages because he's the one who found them, so he's the one who's supposed to read them.
You want to make approach?
Yes.
The material extractions from both of those. So these are just specifically broken down as far as the chats between Mr. O'Keefe's phone and Ms. Reed's phone, correct?
Correct.
And as far as your review of both of the extractions from both of those phones, the material contained within Mr. O'Keefe's phone is consistent with the material contained in the defendant's phone, correct?
Yes, that's correct.
You know what that means? That means Karen Reed did not delete any messages because the same messages were in Karen's phone as were in John's phone.
Want to make approach?
Yes.
Call will proceed to introduce and move the next exhibit. Okay.
Okay.
There's Nancy. We're going to miss Nancy, the court reporter. See, look, there's Nancy, the court reporter. They have this weird system in Massachusetts. I don't know. It's not weird. Sorry, I'm not shading Massachusetts at all. But in New York, we have old-fashioned stenographers that type into the machine. In Massachusetts, they use this system called FTR, where our friend Nancy speaks into this thing that looks like an athletic supporter and speaks the record. It's a talkie system. Here, wait, hold on. Let's see. You can see it again. Nancy's not going to be at this trial, I don't think. So we're sad. We really love Madam Court Reporter the most. We did. Nancy, we're going to miss you. Happy Easter, Nancy.
Okay.
Okay. So that's 6:20.
627.
And then they put them up on the screen.
And now, Trooper Carino, do you recognize what's up on the screen as the next exhibit, sir? Mr. Gilman, I'm sorry. If you could scroll down just a little bit.
Mustang Sally Port. I love that name.
Yes.
And again, from this first page, if you could, the blue bubble is from Ms. Reed, is that correct?
Yes, that's correct.
Being from Mr. O'Keefe, is that correct?
Yes.
And if you could, again, read from this first page as far as date, time, who is speaking, and what is said.
At 9:49 a.m., Karen says, "You've really hurt me this time." 10:02 a.m., "I'm sorry. This is, sorry, it's kind of hard to read. I'm sorry, this has been an issue with me for 8 years. It physically hurts me to see everyone else in their life do things for them, and I'm forced to always be the bad guy." At 10:09 a.m., Karen says, "I am not the same as everybody else. Most of the time, I try to do what is healthy/smart for them. More importantly, I try to support you and what you need. You just lashed out at me and said terrible things. I don't know how you've gone to this point with me when I'm just trying my hardest. You made the point. I made your point."
I mean, he couldn't have more of a flat affect with zero intonation and zero tone, tenor, feeling, or anything else, right? This is the guy. This is the guy that should be doing it. If the car didn't hit you, must have quit. Isn't he the one who found no text on Sandra Birchmore's phone? He found no texts on Matthew Farwell's phone. Matthew Farwell, the Stoughton police officer who took Sandra Birchmore's virginity and then murdered her. He found none of the 32,000 messages on his phone, even though all of those messages were on Sandra Birchmore's MacBook laptop. Yes, that's the guy. That's him. No, Madam Nancy did not pass away. No. Do not spread any rumors. No. She was the court reporter on the Turk trial. Please delete all those messages about that. I am not having any rumor about Nancy. Nancy was the court reporter on the Dr. Turk trial. She's totally fine. She's just not going to be here for this trial because she's otherwise engaged. Stop with that. See, this is how rumors start. This is why I have merch that says I went to Cancun with attorney Melanie Little. Okay. Good grief. I know. It's like wildfire, right? Okay. And then they go to the sidebar.
And continue to beat me down. I have a lot going on too. Physically, I'm falling apart and trying to get answers and help.
If I could stop you there, sir. If I could direct your attention to
Little louder, please, sir.
my book. Sir, if I could direct you to page 5.
Okay.
I'm sorry, bottom of page 4.
All right.
And starting with the blue bubble on the bottom of page 4, again, if you could indicate as to who's speaking, what is said, and the date and times.
Karen says to John at 1:21 p.m. on the 28th, maybe you can call someone.
And if you could continue
Yep.
on through page 5, sir.
On the 28th at 1:46 p.m., John says, like who?
She's
From
not
1:47
retired.
PM.
Nancy is
What
not
time are you coming
retired
here?
either. She's not retired.
And then there
She's
is
in a different
at 2:05.
courtroom.
There's a message,
for
but
the
no
love of the
content.
traveling Mary. Hold
And
on.
the
I
next
had
message
it queued up to where he said kill me, but I think it's before this. Hold on.
With regard to the call log history in Ms. McCabe's phone.
I exported it all out to a PDF so I could view it. And again, like I said, there's, I think, 1,104 phone calls from going all the way back to October of 2020. I want
Pick up on this. He's talking about Jennifer McCabe's phone. I forgot this. I just heard this a little bit earlier. I want to hear this again. And before we move on to the dog bites, because this is interesting. This is Miss McCabe's phone.
it was in her phone.
One of the contentions.
It's going to depend on where that data is being stored.
Now, specifically with respect to Ms. McCabe's phone, one of the contentions Mr. Green had was in regard to a contact for Brian Albert. Is that correct?
Yes, that was another one.
With respect to that, what, if anything,
A screenshot of Brian Albert's contact information. Okay? Listen.
were you able to find within Ms. McCabe's phone in regard to contact information for Brian Albert?
Yeah, so Mr. Green's report said that he located a deleted screenshot of Brian Albert's contact. That was in her phone. The contact for Brian Albert was still in her phone, not deleted. So I don't know, maybe she just deleted the screenshot.
Yeah, why would she just delete the screenshot of Brian Albert's? He just admitted it. Jennifer McCabe had a screenshot of Brian Albert's contact information. She sent it to somebody and she deleted it. He's saying, yeah, maybe she just deleted the screenshot, but the contact information was still in her phone. Huh. Anyone? And she deleted it. Yeah, who did she send it to? He just admitted
Now,
it.
with respect to Ms. McCabe's phone, what, if anything, did you do with regard to the call log history in Ms. McCabe's phone?
I exported it all out to a PDF so I could view it. And again, like I said, there's, I think, 1,104 phone calls from going all the way back to October of 2020, I want to say. And phone calls, FaceTime, they're all, the calls are there, all the records, and they're all stored in different areas of the phone. The only ones that show the wall file deleted were the ones from the 29th going up to the end, towards the end of the day.
Oh, so the only calls that Jennifer McCabe deleted were from the 29th until the end of the day of the 29th. But he had the records all the way going back to 2020. Why? Why would she delete Jennifer McCabe? All of the phone calls and FaceTimes from January 29th of 2020, but he could access everything going all the way back. I mean, why would she only delete them for the 29th of January 2022? But he could access everything else. She had 1,100 or so of them going all the way back to 2020. Do they not want to call him this time? I don't know. Are they going to have to? Yeah.
On the 29th.
And now with respect to the call history, where or how is that typically stored within an iOS device?
I believe that's stored in the call stored -SQLite database.
And with reference to what, if any, difference storage-wise is that SQLite database versus the wall file?
So again, that database where the call logs are sent, it's going to have a corresponding wall file where the data is going to be put temporarily. And then, as I said, it gets automatically deleted by the iOS, by the operating software. It's not user enabled.
And so from your view of those 1,104 phone call history records contained in this extraction of Mr. McCabe's phone, what, if any, opinion do you have in regard to whether or not those items were deleted by any user?
I don't believe they were. And I will say one of the phone calls was from the actual main call stored database. That could have been user deleted but again, it's in two other spots in the operating system. So I don't know how or why the iOS stores it the way it does, and then marks what.
It's really a non-answer, right? He said, I don't know. I don't believe that anyone did. He has no idea what he's talking about. Shaggy wasn't me. No idea. And look at Swiss Misses like, God, I miss Lally's voice. It was really a non-answer. He sounds like he hasn't a clue what he's talking about, says Bex. Yep. the clearing of the Lally throat.
Now, sir, from that you've certain specifically what's
I want to hear
been
the kill
marked
me
as Exhibit 48.
Right, wait, I think it's coming up now.
Okay.
Do you recognize?
Listen.
Do you recognize that, sir?
Yes.
And what do you recognize that?
The first page is Facebook Messenger chats between Karen Reed and John O'Keefe.
And what's contained in there, is that a fair and accurate portrayal of what you observed from the extraction from Mr. O'Keefe's phone?
Yes, it is.
And specifically with reference to those chats between Mr. O'Keefe and the defendant, you also reviewed that material from the defendant's phone as well?
Yes, I did.
Material that you reviewed from the defendant's
Yeah, I think it
phone,
was a little bit before this, because I think it was like they took a sidebar, because here's what the trial channel does. They cut out all the sidebars. And so now I can't find it. But trust me when I tell you that is there. Hot might kill me. Where was it?
from specific people's phones.
It's in two other.
Let's go back to where Lally.
Was that typically with
The contact for.
Well, now I can't find it, but it's in here, and I'll find it for you again. If anybody else wants to scrub through this and try and find it for me, this is Karen Reed Trial Part 63, Trooper Nicholas Garino on the Trial channel on YouTube. I should have written down the timestamp, but I just didn't. What had happened was I just didn't. Be among the cupcakes and truth shall set you free. Thanks on top. Liz loves the law. Has gifted a membership. Thank you, Liz, and thanks to the new member. As an ADA myself, says Mydrin. I can't read what that says. As an ADA myself, my analysis of this case would be dismissal. No way to prove all elements beyond a reasonable doubt. What is the Commonwealth thinking? We don't know. I think they're just not thinking. They're just not thinking. They're just not. Any honorable prosecutor would have at least dropped counts 1 and 3 after what happened with the jury, but here we are. Lola the Good Dog says, Happy Easter. I know the jury is 50-50 male-female, but do you know a diversity breakdown? I do not. Loved your text reading audition. Always the pro, so prepared. Thank you so much. Thank you. I don't know the racial makeup of the jury. On top, may Nancy and her old athletic supporter find peace. She's not retired. On top, she's not retired. Somebody else said here, ShamWow said, how'd you find all these messages? It's not like you. Trooperino, well done. Madam Roz says Nancy was very kind to Boots on the grounds. She stopped on the way to court 2 weeks ago and thanked us all for being so nice to her in Free Karen Read 1. She was on another trial that has completed. Yes, we watched it. The Dr. Turk trial. On top, may God bless Nancy in her current role as gatekeeper of said athletic supporter and the lovely job she does. She does. She was so good. We love Nancy. God bless Nancy. Thanks on top. Michelle says for Spotify, the cruel C, better get a lawyer. Better get a lawyer, son. Better get a real good one. Love Tex Perkins. Hello from a Colorado gal in Oz. Hello, Colorado girl. All right, the cruel C. Thank you. Thank you, Michelle. Appreciate you. Scobuffs. Melissa became a member. Welcome, Melissa G. A lot of Melissas here. Jody Arrington says the Twins College Fund. Thank you. Thank you very much. And so much gratitude, Melanie, for coming out today on Easter for us. You're a rock star. Thank you. We have brunch today. We had a different celebration Friday. So, it was a good time for me. Thank you, Jody. I appreciate you so much. Lolo the Good Dogs is based on his hot mile kill me. Maybe he's the witness that's reluctant to testify. Just one of the many witnesses who are reluctant to testify, because we may look at a little bit of Nicole Albert's testimony too. And boy, I forgot how scared she was on the stand. She was like a scared rabbit. Speaking of Easter. Thank you, Lola the Good Dog. Watching the only fan, the kill me is right in the beginning. Right in the beginning of when he first gets on the stand. I thought it was, I could have sworn it was like after a sidebar, but hold on. Let me just.
Good afternoon, sir.
Good afternoon, sir.
Could you
Just
please
listen to
state
it
your
while we're
name and spell
talking.
your last name for the
You can't hear it, right?
Yep, Nicholas Garino, G-U-A.
Thank you, Andrew, for being here for 8 months.
R-I-N-O.
Since I'm here and slowly getting
And, how
stronger.
are you
Thank
employed,
you.
sir?
We're
I work
wishing
for the
you all the
Massachusetts State
healing
Police.
vibes as
And,
well.
how long have you been a member of the Massachusetts State Police?
Happy Easter to you too, Andrea.
This is my 9th year now.
Right
Now,
in the beginning.
prior
Hold
to
on.
working,
Computer friend.
for Proctor that had reached out to Mr. Whiffen or had any communication.
I'll find it. I'll find it eventually. Thank you, watching the Only Fan, and Andrea, sending Andrea all the healing vibes. You guys are so supportive of each other. I love that so much about you. Anthony Peterson is here. He's stuck on a 24-mile-an-hour car travel. Direction of car, presumed theory, strike on John, arm injury, gnarl, opposite bite marks, etc. Glass under John. Key points of the trial, doubt. Give me your take. Thanks. Oh, you're stuck on the 24-mile-an-hour estimated car travel. That is based on some sort of key cycle BS that you're going to hear about during the trial. And they found some key cycle data from the electronically stored data inside the Lexus. The thing about the key cycle data is, though, a key cycle doesn't have to be when the car starts. It is like when you could just turn on like the accessory part of the car, and that will number a key cycle. The other problem with that data is that there's no date or time of the key cycle. The other problem with the data is there's no location with the key cycle. And so, according to their witnesses, this specific key cycle happened when Karen Read was in front of 34 Fairview. Many people far smarter and with far more time on their hands than I have worked this out on Twitter. And they're saying that the 24 miles an hour in reverse of 60 feet did not happen outside 34 Fairview, but it happened maybe the next day when the car was being reversed out of Karen's parents' driveway in a foot of snow from the tow truck driver because the wheels were spinning. And so it was going in reverse at 24 miles an hour. The wheels were just spinning, and then 60 feet onto the tow truck. A lot of more, right? Key cycle 6221. Yeah, there's a lot of that on Twitter. You can find it. There are people in the chat who are now telling you about it. Key cycle in question happened when it was loaded on the tow truck. And Robin says, Trooper Paul was wrong on that key cycle. It has been determined since that the car was in Karen Read's parents' driveway and the wheels were spinning in the snow during that key cycle. Right. Exactly. It was Trooper Paul, right, that testified about the key cycles. We haven't even, I mean, that's the most fun testimony at all, Anthony. If you haven't watched that, you should watch it because you'll just laugh. Although I know you're from AV's channel, and I'm pretty sure she went over Trooper Paul, right? I don't think there was any glass found under John, but we're going to go back and talk about some things that happened in May of 2023 in the papers. And so there is so much reasonable doubt here. I think it's going to be straightened out during this trial, so stay tuned. Brennan and Two Potted Plants is here. You got to listen to the interview Aiden did with the prosecutor last night. Maybe you could get him on your show, Mel. He's been on my show before. Happy Easter. He's risen. Thank you, Brennan and Two Potted Plants. I didn't watch his show last night, but sure, when I have some free time, I will try and take a listen to it. Homework doesn't work with me because of a very, very, very busy life. But Kim is also pointing out the 1162 key cycle shows the 24-mile-an-hour acceleration was from the tire spinning. Kill Me was in cross. Thank you, Jazzy girl. I don't know, I had it earlier, but trust me when he says under his breath on the stand, he's shown something, and then he says in a hot mic, "Kill me," just like that. We heard it. He really does. It's really true. And the 3-point turn being in reverse and loading onto the tow truck in the driveway to Parents and Titan. Thank you, Kim Robinson. Okay, the next thing we need to look at is something else that Brennan now apparently all of a sudden has a problem with. And remember, the defense has said that they want to show one exhibit in their opening statement. And the Commonwealth has said that they wanted to play one audio and video clip of Karen Reed in their opening statement. And so the judge said, okay, well, I need to see the video clip. And she saw it. And the defense said, we have no objection. And then Lally said, well, I want to see what they want to show in their opening. And so they did. And now Lally all of a sudden has a problem with it, as always, like he does. So let's take a look at that. That is docket number 678. Docket number 678. This is the Commonwealth's motion regarding defense's opening statement. If anybody in the chat is a lawyer and you've never seen Hank Brennan's motions before, your head might pop off and roll down the street because they're never accompanied by an affidavit. They're never in proper form. They're just like somebody threw a whole ink blot at a piece of paper, and here it is. He calls it Commonwealth's motion regarding defense's opening statement. And then he says, the Commonwealth moves for an order that defense counsel refrain from claiming in their opening statement that any of the victim's injuries were caused by any person or animal that was inside the home at 34 Fairview Road. Based on the defense's request to show the abrasions to the victim's arm in opening statement, the Commonwealth notes that the court has ruled the defense is precluded from mentioning any reference to third-party culprit claims prior to establishing a viable basis supported by admissible evidence, and any mention of third-party culprit claims relative to the abrasions would be improper. And if that's confusing to you, it's confusing to everyone. Because I don't recall Chloe ever being named as a third-party culprit because no one is claiming that John O'Keefe was killed by a dog or dog bites. But how impactful would it be if the defense were to just hold up a picture of John's arm in their opening and say, the Commonwealth wants you to believe that these injuries to John O'Keefe's right arm were caused by a car. John O'Keefe was not hit by a car. Keep this in mind. Whatever. They don't have to talk about third-party culprit. The only thing the judge said they're not allowed to talk about is Brian Higgins. They can talk about Brian Higgins and Brian Albert. They can never mention Colin Albert as a third-party culprit because in her mind, that's been proven to be not true. But here comes Hank. Wah, wah, wah. He needs Binky. He doesn't want the jury to be shown the picture of John's arm. First of all, number one, the picture was taken at autopsy. It's coming into evidence. It came into evidence last time. It is going to come into evidence again. There's no way that he can keep that picture of the injuries to John O'Keefe's right arm away from the jury. It's coming in. What are you afraid of? What are you afraid of? You're afraid of the dog bites. You're afraid of the dog bites because if you weren't afraid of the dog bites, you would not have insisted and have been granted beyond all comprehension a 2 full day voir dire on Dr. Marie Russell, who not only testified during the first trial, but she also was extensively voir dired before her testimony in the first trial. Then she testified in the first trial. And then, because the judge agreed with you that maybe she's not really qualified enough to talk about dog bites, in the second trial had 2 full days of voir dire. And even though it was a close call, according to Judge Canoni, Dr. Russell's testifying again. Mr. Brennan, if you are so sure that your experts and your witnesses are going to say that these are not dog bites, what are you afraid of? What are you afraid of? And if your expert, James Crosby, is going to come in and say these are not dog bites, why did you need to go find the alleged Chloe and take a mold of her mouth? If they're not dog bites, they're not dog bites. You don't need measurements. You don't need molds of a dog's mouth taken more than 3 years after the fact, because everyone knows, common sense tells you, dogs lose teeth, their teeth shift. Forensic odontology is junk science. But he's telling you right here between the lines that he's really afraid of the dog bites. And God forbid it gets put into the jury's minds right in the beginning of the case during defense opening. John O'Keefe was not hit by a car. Here are the injuries to John O'Keefe's arm. This photo was taken at autopsy. These injuries were not caused by a car. And then, of course, they're going to say more than that. John O'Keefe's DNA was found on the taillight piece as well. Let me ask you this. We all saw the video of when they're coming out of the waterfall, right? They're coming out of the waterfall. It's snowing a little bit, right? They had to walk down the street. Karen's car was parked like on the street or somewhere a little bit ways away. Anybody think that maybe John O'Keefe might have wiped off the taillights with his hand to, get the snow off the taillights before they left? Is it possible? I mean, they lived together for almost 2 years. You think his DNA or his hair might be on the car? There was no skin tissue found on the car, no blood. We know he wasn't wearing a jacket. Do you think that he was wearing gloves? I doubt it. But do you think that being the nice boyfriend that he was and an officer, a police officer who looks out for other people and is concerned with safety, he might have wiped the snow off the taillight before they left to go to 34 Fairview? Does it strain credulity to think he would do that? No, it doesn't. But anyway, we'll see how she rules on this because, he said he had no objection to them showing any exhibits during openings, but really he does. He doesn't want them to see the dog bites because he doesn't want them to start thinking about the dog bites and the fact that they're not dog bites, because it would be so prejudicial to the Commonwealth, wouldn't it? Because it's all about the Commonwealth's right to a fair trial. Midnight Mike is here and he's gifted a membership and he's awesome. Salty Beach Girl Lori is here, so ready for that butt dial trial 2.0. Let's effing go. Free Karen Reed. Thank you. Thank you. Thank you. Grace Bay says, isn't it insanely prejudicial to the defense to try and limit their opening when he knows this won't be ruled on until the day before openings? Of course it is, but he doesn't care because he kind of almost gets everything he wants. Although the other day we saw the defense get some things, so that was good. On top says, this is the pep rally for Tuesday. I'm practicing my spelling. Also, Queen was a spelling bee winner. I'm in constant religious battle with spell check and autocorrect. You're doing well. Well done. Well done on top. It's not that your spelling is incorrect. It's that sometimes I just can't decipher what it is you're trying to ask me. And I know that you're limited on characters. So I show you grace, but sometimes I just can't understand your question and I feel bad because I know you're very generous, super generous, and you're awesome. Norman is here. And Norman says, Jen's phone records show she called John's phone at 4:49 and 5:04, probably making sure someone didn't answer. Karen called Jen a minute later to say John never came home. That's odd. Thanks for pointing that out to all the people who are newly watching the trial. And I kind of forgot about that too. But I'm going to show you. You're going to come with me right now back to May of 2023. Think about how long ago that was. May of 2023. And some of you who are new to this case do not understand how hard the defense had to fight to get basic items of discovery. After I finish these questions, we're going to move on to that. Emanj, nothing to see here. Thanks for your 5. Can the defense have the garage daddies bring in a polycarbonate taillight to physically show that to the jury? I don't know if they are intending to do that. Can they bring in models they use for testing? I don't know. The answer is I don't know because we have not been able to see the reports of ARCA. We have never seen the reports. They're not in evidence. They've been sealed as exhibits. So I don't know what their reports say. They did testify during the last trial that they did make a cannon, and it was awesome. I think they shot a cocktail glass out of the cannon. Did they also shoot a sneaker out of the cannon? It was awesome. Hi, Annie Painter says, hi, Mel. Has the defense ever asked Jen McCabe why she didn't call Karen after she tried to call John 100 times with no answer? That's a great point. I don't think so. I mean, Karen has never taken the stand. Did they ever ask Jen McCabe that? I don't think that was in any part of her cross. That could be a good question for cross, Annie. That could be good. Well done to you. Kay Willis is here. She's a realtor south of Boston. Anybody who wants to sell their house and get the hell out of Boston, she's your girl. She gifted 5 memberships, and she's very, very, very generous. Thank you so much, Kay. Okay, so all the way back in May 2023, maybe April of 2023. Remember, the first trial did not start until April 2024. And April of 2023 was even before the federal grand jury, before the feds were involved. The defense wanted to get the records of Chloe from Canton Animal Control and the town of Canton. And they couldn't get them because they went there to try and get them. They sent their investigator, and their investigator was told, no, you need an order from the court. We will not give you the records of Chloe. We will need an order from the court. What is also important to note, I believe, is that in April of 2023, Chris Albert, brother of Brian Albert, was elected to the town board in Canton, right? April 2023, correct? April 18th of 2023, as Chief Clerk Jim just said, hold on, I saw that fly by. Where is it? April 18th of 2023 is Turtle Boy's first article. Keep this in mind. Chris Albert is also elected to the Canton Town Board that month, correct? Defense has to make a motion now to Judge Cannoni, who's now on the case because she was not the original judge. It eventually got to her. It was Krupp, and then it was another judge, and there was like random judges, and then it's Cannoni. They have to make a motion. It's a Rule 17 motion. A Rule 17 motion in Massachusetts is when you want records from a third party not connected to the case. Defense had to make a motion to the court asking for the Canton Animal Control records and the Canton Clerk's Office records of Chloe. I forgot about this, but I went back and I pulled it. I pulled the document because, we do receipts here. This is a legal-based channel. We work on facts and documents. The Commonwealth wrote a 30-page opposition, to the defense request to get the Chloe records from Canton Animal Control. Why? Why did they so vehemently oppose this motion? 30 pages. I mean, we have so many. We're up to docket number 670. I think we read before 671. This is docket number 71. This is how old and how long ago this motion was made. And you rarely see a 30-page opposition from the Commonwealth for anything until all of a sudden they want Chloe's records, right? Yeah. So for those of you who are new to the case, this was written by Adam Lally, who tried the first case for the Commonwealth. He did everything himself. He was like a one-man band. Every single witness he examined, nobody else touched a witness. He had, the harmonica in his mouth. He had cymbals between his knees. He had like a horn under his arm. He did the whole thing. There's some interesting stuff in here because I want to show you guys, and you guys probably don't remember this because it was all the way back in May of 2023. All of the things that Lally sets forth in this opposition as facts in this case and how their theory has shifted. Okay. It might blow your mind. You might remember. Here we go. It's 30 pages. We're not going to read the whole entire thing, but I want you to read. I want you to hear the facts as presented by Adam Lally in his official court-filed documents in May of 2023 in opposition to defense getting animal control records. Now comes the Commonwealth and respectfully request that this honorable court deny the defendant's Rule 17A2 motion for an order directed to the Canton Animal Control and the Canton Town Clerk. The defendant's motion should be denied because the defendant has failed to demonstrate that the requested records are evidentiary and relevant. The requested time frame is far too expansive, and the application is not made in good faith, but is rather a fishing expedition for evidence of a purported conspiracy amongst these witnesses, supported merely by speculation and conjecture. Okay. Also, at the same time, understand that the defense was trying to get Jen McCabe's Google records, Jen McCabe's cell phone records, Brian Albert's cell phone records, and Brian Higgins' cell phone records. All of those people that I just mentioned retained their own lawyers. Jennifer McCabe's lawyer was Kevin Reddington, who we just watched try the Turk case. Brian Higgins and Brian Albert both had attorneys as well. That motion was denied. It went up on appeal and finally was reversed partially on appeal to the point where they could get a portion of Jen McCabe's Google search records. But it went all the way up. So the defense has been fighting at this point for more than, it was 22, 23, over a year to get just basic pieces of evidence. And they just can't get it. Here are the facts as set forth by Adam Lally in this filing. You can see the stamp here is May 3rd of 2023, something like that. On January 29th, 2022, at approximately 6:04 a.m., the Canton Police Department received a 911 call from a woman reporting a male party subsequently identified as the victim, John O'Keefe, found in the snow outside 34 Fairview Road. There's a man passed out in the snow. That was Jennifer McCabe's 911 call. You heard it. There's the guy unresponsive in front of 34 Fairview. Come quick. Should have talked to two different operators. At the time of the 911 call, there was an active blizzard occurring with heavy snow and the temperature in the teens. Well, we know. Okay. Officers Saraf and Mulaney, both of the Canton Police Department, were dispatched to the scene along with Canton Fire and EMS. Officer Saraf was the first officer to arrive on scene, where he observed three females waving at him from the front yard area of the residence. Officer Saraf's cruiser camera footage was viewed by the grand jury in this matter and admitted as grand jury exhibit number 56. Now, remember, he's referring now to the grand jury that occurred in May of 2022 when Karen Reed's charges were upgraded from vehicular manslaughter to murder 2. This is before the federal grand jury. So usually when we talk about grand juries, we're talking about two different ones, the state one in May of 2022 and the federal one, which was around July of 2023, after this motion was filed. The footage depicts the weather and visibility conditions during the officer's transit and arrival to the scene shortly after the body of the victim was discovered and the 911 call was placed. In the video, Officer Saraf can be utilizing the spotlight attached to the driver's side of his cruiser as he attempt to locate the calling parties in the darkness and blizzard conditions. Looking at the residents of 34 Fairview Road from the street, the three females were in the left corner of the property in the area of a flagpole and a fire hydrant. Officer Saraf observed the victim lying on the ground as two of the females were performing CPR on him. That was Karen and Carrie Roberts. The three females on scene were identified as the defendant, Karen Reed, Jennifer McCabe, and Carrie Roberts. Officer Saraf further observed the victim to be cold to the touch and not breathing. Exactly. Why is all this necessary for an opposition to a Rule 17 motion? Exactly. Keep that in mind because they go on for another 20 pages with their allegation of these facts. Hold on a second. Hold on one second. This could have been a 5-page opposition, but no, it's 30 pages. Who were they protecting and why? He returned to his cruiser to retrieve his AED device. However, at this time, Canton Fire and EMS arrived on scene and took over resuscitative efforts. Paramedics transported Mr. O'Keefe to the Good Sam Medical Center in Brockton, where he was subsequently determined to be deceased by Dr. Justin Rice hours later. It wasn't really hours later. I think it was 7:50 a.m. I think he was transported around 6:15 a.m. Lieutenant Paul Gallagher, Detective Sergeant Michael Lank, and Sergeant Sean Good, also of the Canton Police, arrived on scene moments after the 911 call had been received. Following the victim's transport from the scene, they began to search for any evidence around where Mr. O'Keefe had been discovered in the mounds of snow on the front lawn of the resident adjacent to the roadway. I'm going to break to tell you that as of the time that they responded to that scene, around 6:08, 6:10 a.m., there was maybe 2 to 3 inches of snow on the ground. There was not mounds of snow, but you guys live there. You can say better than me. They located a broken cocktail-style glass and multiple patches of red that appeared to be blood in the vicinity of where the body had been located. The Canton officers secured the glass and 6 blood samples from the snow as evidence. You know what they didn't secure? The scene. The blood samples were put into solo cups that they got from the across the street neighbor who happened to be the deputy chief of the Canton PD, Tom Kelleher. I can't wait for him to get on the stand because nobody called him last time. He gave him the solo cups. He never came out to see what his guys were doing out there, but he also said, oh yeah, I have a ring camera. It was pointing right at the place where John's body would have been found, but nothing interesting. Nothing to see here. Look the other way. You know what else? The blood samples were never tested. But I digress. Later that morning, listen to this. Ready? Later that morning, the Massachusetts State Police Detective Unit of the Norfolk District Attorney's Office was notified and responded to the scene as well. Trooper Michael Proctor and Sergeant Yuri Buchanek were among the troopers who responded and began interviewing witnesses. Wow, that's interesting, Mr. Lally, that you would put that in your papers. That Trooper Michael Proctor and Sergeant Yuri Buchanek responded to the scene because a couple months after this, 3 months later, in August of 2023, you went on worldwide television when you released your hostage video. You told everyone Trooper Michael Proctor was never at 34 Fairview on January 29th of 2022, and he did not plant any taillight evidence, and he wasn't even there. He said it. But look what Lally wrote in these papers from May of 2023. The MSP Detective Unit of the Norfolk District Attorney's Office was notified and responded to the scene as well. And then they tried some word salad. Remember the salad emoji? We have a salad emoji. Hi, Olivia. Happy Easter. The salad emoji for word salad. Then they tried to say, oh, well, the scene was really the Canton PD. There's a lot of scenes. There's a lot of scenes. There's a lot of scenes. Really? There's a lot of scenes. The scene that how many people just trampled through there? Yeah. Lally tells you in these papers filed May 3rd of 2023, Trooper Michael Proctor and Surrey Buchanek were among the troopers who responded and began interviewing witnesses. They first spoke with Ms. McCabe. Okay, so now you're going to listen to everything that Ms. McCabe told them. When I say Ms. McCabe, I mean Jennifer, not Allie. Ms. McCabe indicated that she and some friends were at the Waterfall Bar and Grill during the evening of January 28th. She arrived with her husband, Matthew, at approximately 9 p.m., following one of their children's high school basketball games earlier in the evening. I'm just thinking, because apparently they changed their story, right? And Proctor and Buchanek say that they went to McCabe's house to interview them. But remember, when the interview was done and when it was typed up, there was a huge gap in between. There were weeks that went by. Huh. She arrived with her husband, Matthew, at approximately 9 p.m. following one of their children's high school basketball games earlier in the evening. At approximately 11 p.m., Mr. O'Keefe and Ms. Reed arrived at the Waterfall together. Ms. McCabe stated that Mr. O'Keefe and Ms. Reed have been in a dating relationship for approximately 2 years and that Ms. Reed stayed at Mr. O'Keefe's house most nights. Ms. McCabe observed Ms. Reed walk into the bar holding a glass cup from C.F. McCarthy's with a clear liquid inside that she believed was a vodka soda drink. Ms. Reed had entered the Waterfall with the glass inside her coat. Mr. O'Keefe and Ms. Reed had been at C.F. McCarthy's bar across the street from the Waterfall prior to coming to the Waterfall. Ms. McCabe observed Mr. O'Keefe to be wearing a baseball hat, jeans, and sneakers. She stated that the defendant and the victim appeared to be in a good mood and did not observe any arguing between the two. throughout the course of the evening. She further described the atmosphere within the bar as friendly, with no arguments amongst any of the patrons. This description of the group and the atmosphere within the bar and between the defendant and the victim was consistent with each of the witnesses present that the troopers interviewed throughout the course of their investigation. As the bar began to close, everyone within their group was invited back to 34 Fairview Road, the residence of Ms. McCabe's sister, Nicole Albert, and her husband, Brian. She observed Mr. O'Keefe and Ms. Reed to leave the waterfall together. As Miss McCabe was arriving, listen to this timeline now, because this all is going to change, but not, because the cross-examination will be fire. As Miss McCabe was arriving at her vehicle, she received a text message from Mr. O'Keefe asking, "Where to?" at 12:14 a.m. Ms. McCabe replied with the address of 34 Fairview Road. At 12:18 a.m., Mr. O'Keefe called Miss McCabe to ask more specifically where the house was located on Fairview. While inside the residence following her arrival there, Ms. McCabe observed a black SUV consistent with Ms. Reed's vehicle, a 2021 black Lexus SUV, arrive in front of the residence from her vantage point at the front door of the home. Ms. McCabe texted Mr. O'Keefe at 12:31 a.m. stating, "Hello," and again at 12:40 a.m., "Pull up behind me," referencing her vehicle's parking spot within the driveway to the home located on the right side of the property if looking at the residence from the street. Okay, listen. After 12:40, Ms. McCabe then observed the black SUV move from its initial place where it had stopped on the street near the driveway and proceed to the left side of the property where Mr. O'Keefe's body was subsequently discovered later in the morning. At 12:45 a.m., Ms. McCabe texted Mr. O'Keefe again, "Hello," and then observed the black SUV drive away from the home. Adele, hello, it's me. Well, everyone, what's wrong with this picture? Oh, too short, Alessi Scissorhands, well done. We know now that Karen Reed's phone connected to the Wi-Fi at One Meadows at 12:36 a.m. But Jennifer McCabe saw the car drive away at 12:45 a.m. She said, at 12:40, she saw the car outside and said, "Pull up behind me." Guess they didn't know. Guess they didn't know when they were making up their timeline together that that data was going to become available about Karen connecting to the Wi-Fi at One Meadows. Yep. I mean, if this isn't reasonable doubt, I don't know what is. I don't know what is. You know what Aussie Insider says, her theme song, "The data don't lie, people do." At approximately 4:53 a.m., Ms. McCabe stated she received a phone call from Ms. Reed looking for Mr. O'Keefe. The phone call was placed by the victim's juvenile niece at the defendant's direction to Ms. McCabe's cellular phone. Ms. McCabe answered the call from the victim's niece, spoke to her briefly, and then the niece handed the phone to the defendant. The defendant sounded distraught over the phone and drove over to Ms. McCabe's home. The defendant told Ms. McCabe that she last remembered seeing the victim at the Waterfall Bar. Now remember, this is all stuff that Jennifer McCabe told Proctor and Buchanan and whoever else interviewed her that day. Ms. McCabe then informed the defendant that she observed the defendant and the victim leave the bar together. Ms. McCabe also later informed the defendant that she had seen them in Ms. Reed's vehicle in front of the home on Fairview. The defendant also informed Ms. McCabe that she and the victim had gotten into an argument the last time that she had seen him. Well, that's interesting. That's where that argument story comes from. It comes from Jennifer McCabe. It comes from Jennifer McCabe. At the last time Karen Reed saw John O'Keefe, which would have been in the car before she dropped him off, they had gotten into an argument. There's the motive, allegedly. The defendant arrived at Ms. McCabe's home around 5:30 a.m. Shortly after the defendant arrived at Ms. McCabe's home, Ms. Carrie Roberts arrived there as well, as she had also received phone calls from the defendant that early morning looking for the victim. Ms. McCabe then drove Ms. Reed's vehicle from her house back to Mr. O'Keefe's house as she was too hysterical, and Ms. Roberts followed along in her own vehicle. While driving to Mr. O'Keefe's house, the defendant stated to Ms. McCabe, "Could I have hit him? Did I hit him?" Ms. McCabe stated that the defendant also told her about a cracked taillight on her vehicle. Once they arrived at the victim's home, the defendant had Ms. McCabe look at the cracked taillight, which Ms. McCabe described as the passenger side right rear taillight, as cracked and missing pieces. That ring video doesn't exist. We saw the ring video when they pull up to One Meadows and they all get out of the car and run inside the house. Nobody looks at the taillight. Emily says everything comes from Jen McCabe. I fully believe she's at the center of the entire cover. Remember, the first time Jennifer McCabe ever said that Karen Reed said, "I hit him, I hit him, I hit him," was on the stand, right? And for those of you just joining, these are motion papers from back in May of 2023, when the Commonwealth, via Adam Lally, wrote a 30-page opposition to the defense trying to obtain Chloe's records from Canton Animal Control. Ms. McCabe and the defendant then entered Ms. Roberts' vehicle to go looking for the victim. The defendant was seated within the back passenger side while Ms. Roberts drove, and Ms. McCabe was seated within the front passenger seat. Ms. McCabe stated that they turned onto Fairview Road from Chapman Street, and at that time it was snowing heavily with the wind blowing, creating poor visibility. Ms. McCabe stated that just prior to 34 Fairview, there's a cluster of trees, and immediately the defendant stated that she saw the victim. This statement initially confused Ms. McCabe and Ms. Roberts, as they were unable to see Mr. O'Keefe's body lying in the snow. Yes, thank you, Lally, for documenting this, says Serenity RPH. Tennessee Cousin says, Chloe who? This is LOL. This is all about the McAlbers being represented by the Commonwealth. Ms. McCabe stated that the defendant screamed to open the door and ran directly over to the body near that cluster of trees and laid on top of him for warmth and began CPR. Ms. McCabe stated that the victim was lying on his back, covered with approximately 6 inches of snow, with his phone on the ground underneath him. Well, that's interesting, because did Jennifer McCabe ever go over to the body? Wasn't she sitting in the car calling 911 and then calling her sister a couple of times and then calling Uncle Brian A, as she had him in her phone, Uncle Brian A, which was weird. How could he have had 6 inches of snow on his body by that time? Well, you know what? We're going to ask the weatherman, because the Commonwealth is bringing the TV weatherman in as an expert witness. So I guess the weatherman's going to be able to tell us how many inches of snow were on the ground at exactly 6:04 a.m., around the area of 34 Fairview, Canton. Right? The weatherman's going to be able to answer that question. It wasn't 6 inches. It was between 2 and 3. Okay, ready for this? The defendant yelled at Miss McCabe twice to Google, "How long do you have to be left outside to die from hypothermia?" or something to that effect. Okay. How long do you have to be left outside to die from hypothermia? How long to die in cold is what was searched at 2:27 a.m. And then again at 6:23 with an incorrect spelling, and then at 6:24 with the correct spelling that reverted back to the 2:27 search. So there's that. But again, with his phone on the ground underneath him. The first time we ever heard about who collected that phone was during trial, when Carrie Roberts said she saw it and picked it up after John was picked up by EMS. But wait, because there's more. On January 29th, the troopers interviewed Mr. Matthew McCabe separately from his wife. Oh, because that's the way you're supposed to do it. Most of them were interviewed in groups. Mr. McCabe indicated that he has known Mr. O'Keefe for approximately 8 years and had met Ms. Reed a handful of times. He stated that he was at the Waterfall Bar on Saturday night and observed the victim and the defendant enter together. He observed the victim to be wearing a baseball hat with a curved visor, and Ms. Reed to be drinking a clear liquid drink, possibly vodka. I don't know, maybe all of my baseball caps have curved visors, but isn't that an interesting detail that I've never, I think, seen before anywhere? Maybe it was in one of the police reports, but I don't remember that because okay. The story has evolved and changed so much. And observed Ms. Reed to be drinking a clear liquid drink, possibly vodka. Yeah, possibly. Could have been water, could have been seltzer, but they got to throw that in there because they have the drunk driving charge. Because that increases the penalty. Vehicular manslaughter while under the influence of alcohol or drugs increases the penalty. And they want to pin it on the girl. Mr. McCabe stated that he left the bar last from his group and was heading to his in-laws' home at 34 Fairview Road. He entered his vehicle and his wife Jennifer was on the phone with the victim telling him to go to 34 Fairview. While at the Fairview residence, he observed a large dark SUV pull up in front of the house on the street. He had been looking out the open front door through the glass storm door and described the SUV's positioning as initially parked in front of the house. See, this is great. This is great because they all want to now, maybe, in my opinion, have the same story about how they saw Karen's car where his body was found, right? So they're all, the two of them, curtain twitching. Jennifer and Matt McCabe looking out the door and the window the entire time, twitching the curtains, as Kathy would say from Gossip, Rumor, and Innuendo. But they shot themselves in the proverbial foot with their timeline and their pull up behind me at 12:40 and seeing it pull away at 12:45 when Karen was hooked up to the home Wi-Fi at One Meadows at 12:36. Mr. McCabe looked out the window some minutes later and observed the same vehicle had moved toward the left side of the property. Minutes following that, he observed the same vehicle driving off down Fairview, heading in the same direction it had been facing while parked. Well, that's interesting, Maddie. Maddie McCabe saw the car drive away. Did you see it reverse 60 feet at 24.2 miles an hour and smash into John O'Keefe? No, you didn't. You didn't see that. But you were curtain twitching enough to see. Nope, no 3-point turn either. Nope. He saw it move to the left side of the property. Minutes following that, he saw that same vehicle driving out off in the same direction. Pin it on the girl. Got to get our stories straight. We have to have seen the car in the area where the body was found. We have to have seen it there. More than one of us has to have seen it there. And it was the two that were elected to have seen it there were Jennifer McCabe and her husband, Matthew McCabe. They're placing it there. That's right. They're placing it there because they have no other evidence. They need eyewitness testimony placing her vehicle there, right? Thank you, No Shrinking Violet. Troopers also interviewed the homeowners of 34 Fairview Road, Brian and Nicole Albert. Well, doesn't say they interviewed them separately. No, doesn't say that Brian Albert is a Boston police officer with the Fugitive Task Squad unit or whatever they call it. And it doesn't say that his brother Kevin Albert is a member of the Canton PD. Both confirmed that they had been at the Waterfall Bar the previous evening with family and friends and had left around closing and returned to their home. Throughout the evening, they both indicated that the victim and defendant, neither of whom they knew particularly well, entered the bar and joined their group. They indicated that several people from the group had been invited back to their home following the bar, and several arrived, staying for approximately 1 hour. Both indicated in their sworn testimony before the grand jury in this matter that their nephew, Colin Albert, okay, so they didn't say this in their original statements. They didn't say this until the grand jury in May of 2022. That their nephew, Colin Albert, while present at the home upon their arrival, had left their home well before any of the guests' arrival from the waterfall. Several other witnesses called before the grand jury similarly confirmed this. Neither were aware that the defendant and victim had planned on coming over, although they would have had no issue if they had been aware. Remember when Brian Albert said, no, he didn't come in the house, but I wish he did. Somebody else said that too, but I wish he did. Several other witnesses called before the grand jury similarly confirmed this. Neither were aware that the defendant and victim had planned on coming over, although they would have had no issue if they had been aware. Neither heard nor saw anything outside of their home over the course of the morning until Ms. McCabe awaked them. 3 witnesses stated, I wish I had, says Alessi's verbal pharmacy. 3 of them. Higgins. Yeah. Did Higgins also say it? Yes, I think you're right. Yeah, this is Brian Albert. All right. Okay, listen to this. Ready? Prior to Ms. McCabe entering their home and waking them up in their bedroom, Ms. McCabe's cellular phone, which was downloaded by members of the MSP following her signed consent. Remember, she signed a consent. She handed her phone over willingly a couple of days later and said she asked the detectives if she would be allowed to delete some text messages from her children. And they said, sure. And she did. And Allie McCabe is her child, right? So if those messages were deleted, what could they have said on them? I don't know. Something about Colin, something about Chloe, something about who knows what. They let her do it. The download shows phone calls from Ms. McCabe's phone to both Nicole and Brian Albert's phones. The first call to Nicole Albert occurs at 6:07:42, and while listed as answered, lasts for a duration of 9 seconds. These are Lally's words. These are Lally's words. These are the papers of Adam Lally. He says 6:07:42, Jennifer McCabe called Nicole Albert. It was listed as answered, and it lasted 9 seconds. The second call to Nicole Albert occurs at 6:08:17, while also listed as answered, lasts for a duration of 7 seconds. You don't have to believe me. Believe Adam Lally. The call to Brian Albert occurs at 6:23 and is listed as unanswered. 6:23:00. Well, that's interesting. So he doesn't answer a call at 6:23:00. When was the second search for how long to die in cold, or how long to DI and CIKD made? 6:23 and some seconds, like after that phone call? I think so. And then at 6:24, right? Mm-hmm. Let's go to some of the questions here. On top says, yes, to please the court, you have said you appreciate the least of my stream of conscious. I'm alive. I do appreciate it. Your stream of consciousness is always appreciated on top. And your super stickers. You're the best. N says, who did Jen think was in her sister's yard when telling 911 a guy was there? She was looking for John. Who else would have been there? Right. And she said, I love John. I loved him. He was my dear friend of 10 years. I loved him. How would you say there's a man passed out in the snow? How about officer down, officer down? My dear friend, John O'Keefe, he's a Boston police officer. Send somebody quick. Get an ambulance. Get an ambulance. It's my sister's lawn. Her husband's. No, there was no. You heard the affect. You heard the calls. Her second way of telling the next operator was there's a guy unresponsive in the snow. Didn't ask for an ambulance. Didn't run into the house to see if her sister and brother-in-law were okay. Because, he was he worked a pretty dangerous job, Brian Albert, the Fugitive Task Squad Force or whatever they call it. You're dealing with dangerous criminals all the time. And holy crap, last time Jen McCabe saw John O'Keefe was in the car outside the house, and now he's dead. Holy crap, I wonder if my sister and my brother-in-law and their kids could have also been killed too. Could be a mass murder situation. No, She doesn't think that. She doesn't even go in. She calls them twice. Guess she got them because they were 9 and 7 seconds. She says something like, come out here, or are you going to leave me alone, or I got this, or whatever. Because we heard a recording. Because when Karen Reed jumped out of the car to run towards her boyfriend, she had been calling John's phone and the voicemail picked up. And so it was taped on John O'Keefe's phone when Karen dropped her phone in the back seat, what Jennifer McCabe was saying in the front seat. And it's kind of hard to hear, but it sounds like she's talking to her sister and saying something like, are you going to leave me out here alone? Or something like that. Someone's coming out to help. Something like that, right, Norman? Yeah. Kay Huber also became a member. Welcome, Kay. Spanky's playing the harmonica for 2.0. Thank you, Pokey. Where's Gumby? Melanie's head popped off bucket. It's been here for 5 months and says, here for you in trial too. Thanks for dedicating your time. Oh, I love you more. Love you more. And I love your name even the most. Except for Melanie Little's left swipe in StreamYard also is a really, really good one too. The snark tank. You guys are, yeah, and there she is. See? Takes me no longer to say. And there she is. Melanie Little's left swipe is. They're sending someone over, is what she said in the recording. Thank you. We're so collaborative here. She also told 911, yeah, he got out of the car. That's right. You're correct. You're correct. Cooperated Washinables says, didn't Lally tell the court that there was video that showed Karen Reed hit John O'Keefe when they indicted her? Did you tell the court that, or was that something that was just reported on the news? We watched the indictment again recently, and I don't remember him saying that in court, but I remember it being reported on the news. Investigators say they have ring camera footage of the incident. News at 11. Can the defense use this, or has Bev already said no? Yeah, I don't think that anything that any attorney says in court is not evidence, and so the answer to that would be no, but I don't remember him saying that in court. Shaggy wasn't me, says funny because Judge Bev said the Canton PD was not the scene. Funny, right? Thank you for your super chat. Michelle Smith gifted 5 memberships. Thank you, Michelle. You're awesome. And Sandy B. Where they went in the house with everyone pulling off their shoes is the story. Where? Oh, it's in his closing. It's in Lally's closing. He says that, you see this video of everyone coming in the house, going back to One Meadows, and John O'Keefe always made everyone take their shoes off when they came in the house. And Karen Reed did not take her shoes off that morning because she knew that he was dead. She knew he was never coming home. That's in Lally's closing. Thanks, Sandy B. Isabel says, I think initially only a few people were involved in the cover-up, but now it's gone out of control. Or maybe just some people look the other way, right? Isabel's here from New Zealand, and she knows about the story. Thanks, Regina, for becoming a member. ShamWow said there is more 1210 testimony than 227. That's right. Everyone knew about 1210, 1210. Colin left at 1210, 1210, 1210. Everyone knew that. Lally's fading nicotine patch. Blackbird says, just want to hear you say my name. Say my name. Beyond say my name. Lally's fading nicotine patch. Well done, Blackbird. Well done to you. All right, there's more here. I want to try and get you out of here by 7:30 because Bettero is going to be on with Nurse Kim, and I'm going to teleport you over there so you're not going to miss a thing. Troopers also interviewed Mr. Ryan Nagel. Mr. Nagel's sister, Julie, had been at 34 Fairview the evening of January 28th, visiting with the Albert's son for his birthday. Mr. Nagel stated that he had been contacted by his sister asking for a ride home. His friend drove with Mr. Nagel in the front passenger seat and his girlfriend in the rear of the cab of his friend's Ford F-150 pickup truck to Fairview. As the truck was driving down Cedar Crest Road, he observed a set of headlights of a mid-sized black SUV coming from the opposite direction on Cedar Crest, and the truck he was traveling in yielded to the SUV, making a right turn onto Fairview, and then followed behind it after executing its left turn onto Fairview. Mr. Nagel stated that the truck stopped directly in front of the driveway to the home and remembered the black SUV stopping along the right-hand curb toward the left side of the property. He remained within the truck while his sister exited the home and asked them to come inside. He declined the invitation, and his sister eventually decided to stay at the home and make other transportation arrangements. Yeah, because she really, really wanted to hang out with Jen McCabe, seemed like. Remember, this was before testimony, and I think Nagel's story was a little bit different when he testified. As his sister returned to the house, Mr. Nagel observed the black SUV pull up an approximate pull up an approximate 1 to 1.5 car lengths to the right left edge of the home's property. Again, they need another eyewitness to say that Karen's car landed there, where the flagpole was located along with some bushes. Remember the bushes, okay? There's bushes there by the flagpole. He stated that the SUV's driver did not appear to place the vehicle in park at any point that he observed it, as the rear brake lights were illuminated throughout his observations, to include the top center light. Mr. Nagel reported hearing no noises coming from the interior of the SUV. Mr. Nagel indicated that as his friend pulled away from the side of the road when they were leaving, they drove past the black SUV. He observed the interior light on within the vehicle and a Caucasian female operator seated inside the vehicle, holding the steering wheel at 10 and 2, staring straight ahead of her. It's awfully specific, right? Troopers also later interviewed Mr. Nagel's sister, Ms. Juliana Nagel, as well as her friend, Ms. Sarah Levinson, both of whom had been present at the home on Fairview on January 28th and 29th, both of whom had been given a ride home by the McCabe's. Well, I don't know, Olivia, does anybody here know when exactly Sarah Levinson and Juliana Nagel's statements were taken? It was a long time after. Hang on. Yes, Jennifer, yes. All of this is in opposition to the dog records. They're putting a narrative out there in the public because, public filing and all. Right around the time that Aidan Carney started reporting on this case. So think about it. They're getting their narrative out there. Yeah, I think, wasn't she interviewed? Juliana Nagel interviewed more than a year later. I think so. Oh, no, Ryan Nagel. Yeah. I have the statements somewhere. I don't remember when Juliana Nagel gave a statement, but it was not in close proximity to January 29th, 2022, as far as I remember. Something like 10 to 13 months, October 2022. Thank you, Lori Marie. Maxi Uber Eats says, the fact we have to go backwards and can see the bull is crazy. This whole right. 8 months later, Juliana Nagel's statement was given. And by that time, wait till you see what she says in her statement. Okay. Both of whom had been given a ride home by the McCabe's. Oh boy, that story sure had a lot of detail, didn't it? The peanut butter in the back seat, the bread in the back seat, joking about peanut butter sandwiches. Yeah, that story had a lot of detail. But you know what? Matt McCabe couldn't remember. He couldn't remember the car, the make and model of the car that his wife had a little over 2 years ago. Does everyone here remember the cars in their household from 2 years ago? I know I do. I could probably name every car I've had in the past 10 years. It's crazy. He didn't know that, but he remembers, the peanut butter talk and looking out the window, curtain twitching and seeing the car and exactly where Karen's car was, right? Remembers all that stuff. Both indicated they had been at the home on Fairview for Brian Albert Jr.'s birthday on that evening. Both provided a list of other individuals there. Both indicated that the Alberts, Brian and Nicole, arrived later in the evening from the waterfall and listed those in that group to include the Alberts, the McCabe's, and Mr. Higgins. Both indicated that no one else entered the home while they were there and that they left and got a ride home from the McCabe's. Ms. Levinson recalled Ms. McCabe saying that someone else was coming. However, that person never arrived. Really? Would Jen McCabe announce to the group, oh yeah, some more people are coming? I don't buy that, number one. Number two, both indicated no one else entered the home while they were there. Well, that's so interesting too, because didn't Brian Higgins testify on the stand? I think his lawyer was standing next to him when he said this, that he saw an unknown male, a tall male with dark hair, enter the home that he didn't know. There was some proffer or some voir dire that happened with Higgins where his lawyer was standing right next to him. Juliana Nagel stated that she had called her brother Ryan for a ride home at approximately 12 a.m. While waiting for him to arrive, she was looking out the kitchen window and observed an SUV stopped by the mailbox with the front of the SUV facing Chapman Street. She stated that now remember, if this was like 8 months later and she's like besties with like Jen McCabe, didn't she like walk her dogs or dog sit for her or something? She had like some relationship with Jen McCabe and the McCabe family. There's time to like now add more detail. So now Juliana Nagel is also curtain twitching. She's looking out the kitchen window. She observes an SUV stop by the mailbox with the front of the SUV facing Chapman Street. She stated that she further observed the SUV travel along the front of the house and stop between the mailbox and the flagpole where it came to a stop. She observed the SUV further pull up closer to the flagpole and stop again. Wow. How many witnesses do we have now who are placing Karen's vehicle in the exact spot where the body ends up being? And remember, this can all be reverse engineered because all of these statements were given long after the fact. Julie just want to be one of the cool kids. I wish that I could be like the cool kids. The cool kids, they want to fit in. Remember that song, Stephanie? I wish that I could be like the cool kids. We think it's song lyrics here. It's a thing. She went outside to speak with her brother and noticed that it was lightly snowing at this time. After her brother declined her offer to come inside and she indicated to him she would arrange an alternative way home, she went back inside the home with the SUV still parked in the aforementioned position, right? Where's the Jeep? Where's Higgins' Jeep? Where is Higgins' Jeep? Nobody sees it. Nobody sees it except for Matt and Jen McCabe. Ms. Nagel stated that she left the residence in the McCabe's vehicle sometime between 1:30 and 2 a.m. with Mr. McCabe driving, Ms. McCabe in the front passenger seat, her behind the driver in the back seat, Ms. Levinson seated next to her behind Ms. McCabe. Okay, so picture this, okay? She's sitting behind Matt, the driver. So the lawn, as they leave 34 Fairview, is on her right. Sarah Levinson is blocking the window next to her. And Jen McCabe is in the front passenger seat, turned around, talking to them about the peanut butter. Mr. McCabe reversed out of the driveway. And as they traveled past the house, she indicated that she thought she saw something she described as a dark object in the snow by the flagpole, but could not determine what it was. A dark object. Could it have been a bush? For the first time ever on the stand during trial 1, she said, I saw a black blob on the lawn that was 5 or 6 inches long. 5 or 6 feet long, right? She says about 6 feet long. For the first time ever. For the first time ever. But when she first gave her statement, which was like 8 months after this, and a lot of dog sitting for Jennifer McCabe. Tell me, chat, was she dog sitting for Jennifer McCabe? Something happened. Yeah, she couldn't determine what it was. And then even, the next day when apparently it was reported that John O'Keefe was found dead on the lawn, she never told anybody. No, never told anybody. She didn't say, holy crap, I thought, and she also admitted that she was hammered on the stand, right? She saw she was hammered. She said she was hammered on the stand. Sus. Reasonable doubt. Reasonable doubt. Reasonable doubt. Later that day, January 29th, troopers Matthew Dunn and David DeChico interviewed Ms. Carrie Roberts. Oh, remember, she's telling them everything. Didn't they interview her from Jen McCabe's house? Do I recall that correctly, you guys? She's telling them everything was in the group text. Ms. Roberts stated to them that at approximately 5 a.m., she received a call from the defendant stating that John did not come home. It was snowing and she was worried. The defendant the first time the black blog came out was the federal grand jury? I thought it was on the stand. Was it the federal grand jury? I don't know. I could be wrong. Yes, absolutely can use previous testimony during a retrial, 100%. Helicity, everything that was testified to under oath in front of either grand jury or the trial. You can also use deposition testimony in a civil case, or if they do criminal depositions, you can use that to impeach as well. It's all fair game. It is. It's all fair game. Had to be the federal grand jury. I thought it was during when she actually got on the stand, but I could be wrong. Federal grand jury, she said a dark shadow. Well, here's the thing. She said in her original statement it was a dark object, but that was like 8 months after. The defendant further stated to Miss Roberts, John's dead. Carrie, I wonder if he's dead. It's snowing. He got hit by a plow. Well, we listened to Carrie Roberts' call to Sergeant Good, Canton PD. She didn't say any of this. Did she? In fact, she was giggling with Sergeant Good. His girlfriend's worried he didn't come home. There was this blizzard party. Did you pick anybody up last night? Maybe you just slept on someone's couch. None of that. She didn't say any of that. Ms. Roberts got dressed and left in her vehicle, eventually meeting the defendant at Ms. McCabe's home, where she observed the defendant to be hysterical. Ms. Roberts stated that she believed the defendant was still intoxicated in the morning and had told her that she did not remember last night. Ms. Roberts reported the defendant as stating to her, I was so drunk I don't even remember going to your sister's last night, referring to Ms. McCabe's sister, the homeowner of 34 Fairview Road. Ms. Roberts followed the defendant's black Lexus SUV back to Mr. O'Keefe's house. They went inside the home for a period of time, looking for him to no avail and checking on the victim's niece. While at the victim's home, Ms. Roberts stated that the defendant had told her and Ms. McCabe about a cracked rear passenger taillight and showed the both of them that area of her vehicle. Well, she testified to something different on the stand, I think. I think she testified that she first noticed that she had a little tiny piece, a little hole missing from her taillight when she was outside, when she was following them back to One Meadows. So the story changes a little bit. I heard some people saying that Aiden did a show, like maybe it was last night, and was saying that there's a lot of stuff that's to be revealed about Carrie Roberts' testimony. So I don't know anything about that, but put a pin in it. Still no mention of a dog. Nope. This is all in relation to the dog records. It's 30 pages long. And she says she showed the both of them that area at the taillight at the victim's home. Well, there's no ring camera video of that. Ms. Roberts then drove her vehicle with Ms. McCabe in the front passenger seat and the defendant in the rear passenger side to 34 Fairview Road. She and Ms. McCabe were scanning the sides of the roadway along the drive looking for the victim, while the defendant periodically screamed and texted on her phone as they drove. Ms. Roberts described the weather as whiteout conditions as they were driving around. Here's a good reminder for everyone to hit the like button so we don't have to turn off the air conditioning. And let's hope it doesn't get hot in Dedham this week, because remember the last trial? If they had the air conditioning on and the witnesses weren't speaking loudly enough, the judge would threaten to shut off the air conditioning. Hold on, I'm parched. As they arrived in the area of 34 Fairview, Ms. Roberts stated that the defendant screamed, "There he is, I see him," from inside the vehicle and screamed to be let out. Even after initially exiting the vehicle, Ms. Roberts stated that she still could not see the victim in the conditions and further stated that his body was covered in snow. She stated that the victim's body was approximately 12 feet from the roadway. Well, that number keeps changing, doesn't it? Guess what else? Nobody ever took pictures of where John's body was, and so nobody really knows. No measurements were ever taken, but Carrie Roberts says 12 feet from the roadway. She observed him to have a swollen right eye with a laceration above it and blood around his nose and mouth. Ms. Roberts stated that they immediately began CPR and Ms. McCabe called 911. Ms. Roberts stated that she observed the victim to be lying on his back with his arms by his side. She noticed that his right eye was swollen shut and that there was blood coming from his nose and mouth. When the paramedics arrived and lifted the victim's body onto the stretcher, Ms. Roberts observed the grass underneath the victim's back, not covered in snow as the remainder of the area was. You know what it doesn't say? Ms. Roberts observed his phone underneath his body. What if his body was still warm when he was put out there? Would that have melted the snow underneath his body before hypothermia set in? And also, if he was actively bleeding, what does that indicate to you? It was wicked cold that night, you guys. Wicked cold. No frostbite. Hypothermia. Allegedly, he's hit around, I don't know. It was 12:45 initially. Now it's 12:30. Would have been out there for 5.5 hours. The defendant repeatedly asked Ms. Roberts, Ms. McCabe, and the officers and paramedics on scene, "Is he dead?" repeating that phraseology numerous times to each. The defendant further grabbed Ms. Roberts by the arm at one point and asked her if they were really working on John or was he already dead. In addition, Trooper Buchanan interviewed Nicholas and Karina Kolakithis. They were my favorite witnesses, I think. Well, some of them. Both were present with the group at the waterfall on the evening of January 28th. They arrived there at approximately 9 and 9:30. Remember, Karina didn't even want to go out that night, and her kids were like, "Come on, Ma, you got to get out every now and then. You got to go." She didn't want to go. She probably wishes she didn't go. They arrived there, respectively, as they came in separate cars following their daughter's high school basketball game. They had known the victim for approximately 5 to 6 years and had met the defendant a handful of times. They stated that the victim and defendant arrived at the waterfall together at approximately 11 p.m., arriving from C.F. McCarthy's across the street. Mrs. Kolakithis spoke for a period of time with the defendant and observed her to be drinking vodka soda cocktails while at the bar. Well, what did Karina Kolakithis say on the stand? Did she ever say vodka? I don't think so. I think she said clear liquid. She also recalled the defendant pushing quite a bit for a member of the group, Christopher Albert, the owner of a local pizza shop, to go across the street after leaving the bar to keep partying while he made pies for everyone. Yeah, I don't think she said, Karen Reed said she wanted to keep partying, make pies, keep partying. Notice how they had to throw that in there? She didn't want to keep partying. She wanted to go home. That's why she left John there, because she got mad that he never told her it was cool for her to come in. When it was time to leave, Mrs. Kolakithis indicated she walked outside with Miss McCabe and observed the victim and the defendant to walk out together and proceed to the left of the driveway and up Washington Street, where their vehicle was parked along the curb, facing back up toward the waterfall. Mrs. Kolakithis indicated that her vehicle was also parked along Washington Street, but further down and facing the opposite direction. From there, she observed the defendant walking toward the driver's side door of her black Lexus SUV. She further indicated that during the course of her conversation that evening with the defendant, wait for this part, the defendant complained about the victim's mother and the lack of private time the couple had for vacations because of the children, their activities, and responsibilities. Well, I mean, if you didn't think anybody tried to alienate Mrs. O'Keefe from Karen before, or alienate Karen from the children, you need to look no further than Adam Lally's own words in May of 2023. She also described her as fine and did not believe the defendant to be overly intoxicated. Maybe we should listen to Karina Kolakithis' testimony again one day. But again, go to the trial channel on YouTube. You can find it. It's isolated and you can listen to it. And also, I don't know, she has Crohn's and a lot of other gastrointestinal disorders. Didn't she have something like, maybe when she was in her 20s? I don't know. Don't quote me exactly. 9 surgeries to her colon almost the entire thing removed. Is pizza the thing that she really wants to eat? I don't know. But, it fits the narrative, so let's throw it in there. She wanted to keep partying, really, is the narrative, right? On January 30th, Troopers Buchanan and Proctor interviewed Canton firefighter Katie McLaughlin. Well, Katie McLaughlin, for those of you who didn't watch the first trial, went to school with a girl named Caitlin Albert, daughter of Brian and Nicole Albert. She went to school with her. After she testified on the stand that she went to school with a girl named Caitlin Albert, many people on the internet started sending pictures to the defense team, putting them up on Twitter and Reddit and wherever, where Katie McLaughlin and Caitlin Albert were in hot tubs together, in bathing suits together on the beach. So baby showers, wedding showers, she didn't just go to school with a girl named Caitlin Albert. She actually might have been good friends with a girl named Caitlin Albert. This interview was also set up by Kevin Albert, brother of Brian Albert. Kevin Albert was, or maybe still is, dude, where's my gun? Police officer or detective or something like that at Canton PD. Kevin Albert set up this interview with Katie McLaughlin. They were supposed to be conflicted out of this case. However, he set it up. And they did it. I think they did it at Canton PD. All right, you can correct me if I'm wrong. And it's been reported that Katie McLaughlin has not been back to work since after her testimony during the first trial. I don't know what that means. Maybe it means nothing. That's the word on the street. We're praying for you, Katie. Maybe she doesn't want to come and testify. Could you blame her? She had been assigned to Station 1 on the 29th and indicated that at approximately 6 a.m., Canton Fire and EMS had been dispatched to 34 Fairview Road for a male party in the snow and unresponsive. This is going to be really important. So listen up. Upon arrival, Ms. McLaughlin observed the victim to have trauma to his face and eye area and vomit in his mouth. She observed the victim to be dressed in jeans, socks, and one black Nike sneaker. The victim's shirts were cut and his chest exposed for chest compressions. Ms. McLaughlin had exited the ambulance to speak with the defendant as to the victim's identity and medical history. The defendant provided the victim's name and date of birth. Ms. McLaughlin asked the defendant if she knew where the victim had suffered trauma to his face and eye. And the defendant turned to her friend and stated repeatedly, I hit him. In response to the paramedic's question. Again, Katie McLaughlin's question was, how did John O'Keefe suffer the trauma to his face and eye? Then again, allegedly, Karen turned to her friend, Jennifer McCabe, and said, I hit him. That is why Yuri Buchanan called this in as a domestic dispute. She's back to work now? Okay, good for her. Yuri Buchanan called this in as a domestic. Not as a car accident, not as a motor vehicle accident, as a domestic dispute. There's nothing wrong with Nancy. Steve, Nancy's fine. Nancy's fine. Stop. What is wrong with people? Right. We all know damn well that if anyone confessed to a crime, thank you, Ryder, on the scene, they'd be locked up that second. Of course. Meaning I hit him, like I smacked him across the face. Is that what she thought she meant? Because that was the question she asked. Do you know how he got trauma to his face and eye? Following their initial witness interviews on January 29th, Troopers Buchanan and Proctor then proceeded to Good Sam to view the victim. Here's what they observed. 6 bloodied lacerations varying in length on his right arm. Well, we know there's more than 6. The cuts extended from his forearm to his bicep. Both of the victim's eyes were swollen shut and black and blue in color. The troopers observed a cut to the right eyelid area of the victim. The victim's clothing consisting of blue jeans, an orange t-shirt, long sleeve gray shirt, and boxer shorts were soaking wet and saturated with blood and vomit. The victim was also observed to have one black Nike sneaker with a white Nike logo on the side. His clothes were soaking wet and saturated with blood and vomit. And then from there, as we know, those clothes were put into a plastic bag. What happens to DNA when it is wet and put in the wrong sort of evidence container? The DNA evidence denigrates, we know that. Right? The victim's medical records were admitted as an exhibit before the grand jury in this matter as well. Throughout said medical records, the attending physician and medical personnel described the victim's injuries at lengths. Said description of his injuries and medical condition include right superior orbital ridge region, approximately 7 millimeter laceration, plus surrounding soft tissue swelling contusions, positive breath sounds bilaterally, pulseless, positive superficial abrasions right forearm. Time of death is noted as 7:50 a.m. Well, you know what there's not? Injuries consistent with being hit by a car. On January 31st, Dr. Irene Scorti-Bello, he spells it wrong, B-E-L-L-O-W. It's supposed to be B-E-L-L-O. From the Office of the Chief Medical Examiner, conducted the autopsy. The doctor advised the troopers that she observed several abrasions to the victim's right forearm, 2 swollen black eyes, a small cut above the right eye, a cut to the left side of his nose, an approximately 2-inch laceration to the back right of his head, and multiple skull fractures that resulted in bleeding of the brain. We know because we watched Dr. Renee Stonebridge's testimony in the most underrated testimony of the trial. Fractures in the frontal lobes, in the temporal lobes, in the back of the skull. Brain bleeds here, 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 consistent with what? Fight or a boxing match. Come on, man. Dr. Scorti-Bello further advised the troopers that the victim's pancreas was a dark red color, indicating hypothermia was a contributing factor to his death. Dr. Scorti-Bello opined from her examination that the significant blunt force trauma injuries occurred prior to Mr. O'Keefe becoming hypothermic, as evidenced by hemorrhaging in his pancreas and stomach. Mr. O'Keefe had arrived at the Good Samaritan Medical Center with a body temperature reading in the low 80s. The doctor opined that the extensive injuries to his head likely rendered Mr. O'Keefe incapacitated. The doctor further opined that upon viewing Mr. O'Keefe's injuries and her examination of the body, she observed no signs of Mr. O'Keefe being involved in any type of physical altercation or fight. Well, isn't that interesting? Because how many autopsy reports say what the decedent did not die from? What did not cause the death? Such as, does not appear that this person died in a fire. Does not appear consistent with a fall from a building. Does not appear consistent with a drowning. But in my opinion, because Dr. Scorti-Bello would not change her manner of death on the death certificate from undetermined to homicide, she was told, well, could you at least put this in your report? I mean, you just don't see it. You just don't see in autopsy reports what the person did not die from. They're also not consistent with a car accident, but they are consistent with a beating and an animal attack. And all of this, remember, we're still in the papers from Adam Lally to prevent the defense team from getting the animal control records from Canton Animal Control. And again, I'll scroll through this a little bit slowly so that you can read it at your leisure. But she describes the right arm injuries. The doctor testified the victim had abrasions on his right arm. She described abrasions as scratches caused by a blunt object Contact with a blunt object. Well, isn't blunt the opposite of sharp? So how does that gel with the taillight bite theory? I don't know. She went on to describe them as a cluster on his right upper arm and his right forearm, mostly linear and ranging in size from a few millimeters to up to 7 centimeters. Dr. Scortibello testified that throughout her thorough external examination of the victim's body, she observed no signs of an altercation or fight. No fight here. Look the other way, everyone. She also testified extensively to the injuries or swelling of the victim's eyes. She testified that from her examination of the victim, both external and internal, that the bleeding and subsequent swelling around his eyes was related to the very small fractures in the skull. She testified specifically that the injury initiated or started in the back of the head, caused all of the fractures in the skull, and then the eyes got red or black or purple because the seepage of blood from the small vessels. Well, we went over Dr. Stonebridge's testimony, and also I don't really know that this is exactly what Dr. Scortibello testified to during the trial. And then they talk about at approximately 4:30 p.m. on January 29th, Troopers Buchanan and Proctor arrived at a residence in Dighton, Mass. At the home of the defendant's parents. Wait a second, what's wrong with that? Did they arrive there at 4:30? Because remember, these papers are from May of 2023. I don't remember exactly what time they got there. But they got back to the Sally Port around 5:30, right? And we know that Proctor lied on his search warrant applications and said that they seized the car at 5:30. Never mind the details. Not important. Just trust me, bro. Right. Upon their arrival, they observed a large black Lexus SUV bearing this license plate registered to the defendant parked outside the garage door in the driveway to the home. The troopers observed the right rear passenger side taillight to be shattered and large red pieces of plastic to be missing from the taillight. Well, that's interesting because nobody took a picture. And that is not what the Dighton police officer, Trooper Nick Barros, said. He said it was cracked, but not completely damaged. But this is what Lally's putting in his public papers, his court filing in May of 2023, about a year before the first trial. They observed the right passenger side taillight to be shattered and a large red piece of plastic, a large red piece of plastic to be missing from the taillight. Oh, just one. The troopers were invited into the home and observed the defendant seated on the living room couch. The defendant agreed to speak with the troopers. The defendant indicated to the troopers that she had met the victim at C.F. McCarthy's bar in Canton at approximately 9 p.m. the evening prior. The victim had been there with friends prior to her arrival. She stated that the victim was drinking beers. She was drinking vodka sodas. She described the glassware she was drinking out of as a vase style. The defendant stated that she and the victim left C.F. McCarthy's and went to the waterfall, but denied that she had taken any drink from one bar to the next. She stated that they were at the waterfall for approximately an hour, and during that time, there were no arguments amongst anyone present there. When she and the victim were leaving the waterfall, she stated they were invited to a house on Fairview Road. The defendant stated that she had dropped the victim at the house on Fairview and went home since she was having stomach issues at the previous bar. The defendant stated that she dropped the victim off, then made a 3-point turn in the street and left. Yeah. It's not what the curtain twitchers saw. She stated that she did not see the victim enter the residence. The defendant indicated that she first observed the broken taillight in the morning and did not know how she had broken it the previous evening. The victim was uninjured when she dropped him off at the house. However, when she discovered him the next morning, she observed him lying face up, snow on his legs, his eyes swollen, and blood coming from his nose and mouth. Well, you know what's interesting about all the things they say that Karen said? This interview is not recorded in any way, unlike the 3-hour statement recording of Dr. Turk that they did in 2020. Wasn't recorded in any way. She didn't sign it. And this is just what they say, she said. She stated she began providing him with mouth to mouth. The defendant further stated that she had attempted to contact the victim throughout the night, calling and texting him numerous times with no response. Well, that's true. She did do that. She did leave some pretty nasty voicemails because she was being ignored. She stated that they had a verbal argument that morning over what the defendant fed the victim's niece for breakfast. Right. She took her to Dunkin' Donuts drive-through and bought her an iced coffee. The troopers further asked the defendant for contact information relating to the people she had indicated were present at the bars. The defendant obliged, and prior to providing said information, the troopers observed the defendant to enter a numerical passcode into her phone to unlock it prior to retrieving said data. So they were looking over her shoulder, and now they know what her password is because they saw her enter her password. The black Lexus SUV was seized from the driveway of the defendant's parents' home in Dighton on January 29th. Nobody took a picture of the taillight. The vehicle was then transported via tow to the Canton Police Department. Yep, and the tow truck driver is on the witness list. Anybody ever have AAA tow your car? When they get there, don't they photograph your car from every angle with about 20 pictures? You think the tow truck driver didn't photograph the car? I don't know. On February 1st, or note any damage on his report, on his tow report. I mean, you have to be like on the list, right? To be a tow truck company that's allowed to tow for the MSP. Like, it's not an easy gig to get, I would say. On February 1st, members of the MSP Crime Scene Services Section, Crime Lab Chemist, and Trooper Joe Paul of the MSP Collision Analysis and Reconstruction Section responded to the department. They observed fragments of broken glass on the rear bumper of the vehicle. Yep, they did. And you know what? It didn't match anything at the scene. Didn't match the cocktail glass. But they want you to think it did. The rear right passenger side taillight was shattered, and pieces were observed missing from the red and clear areas. Well, now there's pieces missing. When Joe Paul gets there. But when Trooper Proctor and Buchanan saw it in the driveway in Dighton, allegedly there was only one red piece missing. So which is it, guys? On the right side of the rear tailgate, a deep scratch and minor dent were observed. Well, yeah, that might have been from like a crowbar that was used to maybe tool marks from, some, I don't know. On the right side of the bumper above a small red light, 2 scratches were observed as well as one area where the paint was chipped off. Troopers from the cars unit performed a rapid acceleration forward and reverse tests with the vehicle and noted no deficiencies with the vehicle's braking system or other operations. The troopers placed a training figure resembling a human, approximately 6 feet in height, behind the Lexus. The vehicle was operated by a cars trooper and documented with video from crime scene. Did you ever see the video with the dummy in it? I mean, I remember seeing the dummy in the Sallyport video, but I don't know if I remember that video. The vehicle was placed in reverse and started to travel toward the training figure. The rear view camera within the vehicle was operating properly, displayed on a screen in the center of the dashboard, and provided a 360-degree overhead visual. As the Lexus traveled closer to the figure, both auditory and visual cues with the vehicle sounded off, indicating an obstruction to the rear. Well, then if she did hit him, she would have heard it, right? And she wouldn't have hit him, right? The whole thing is ridiculous. The whole thing is absurd. And if they go on for another however long, many pages, it's 30 pages long. This is an opposition to get the Canton animal records about Chloe. Okay. I will slowly scroll through this in case you would like to read this at your leisure. because a lot of you don't remember all of this from May of 2023. About the Ring camera and all the reasons why Lally doesn't think that the Canton animal control records are even relevant. Because at the very end, I mean, they go into how many drinks she has and, how many things are on the video because they got that video and the library video. And all of the reasons why they don't think this has anything to do with Chloe. Everything the niece and nephew said about Karen and John's relationship. I mean, this is really literally an opposition to Canton animal control records. And why we don't think they're relevant. And they say, Lally says, in the absence of any evidence that the victim entered the home on Fairview or had any interaction with the animal in question, the defendant's request is unreasonable. The time frame requested by the defendant is far too overbroad, requesting records from 2015 to present, with no showing as to why so expansive a set of records is even tangentially relevant to this case. The defendant further states that the photographs of Mr. O'Keefe's injuries suggest that he was severely beaten and left for dead, having sustained blunt force injuries to both sides of his face, as well as to the back of his head. Counsel avers that there is evidence of defensive wounds, a cluster of deep scratches and puncture wounds to his upper arm and forearm. The defendant asked the court to take the inferential leap that these injuries, which are wholly inconsistent with the injuries noted by both the emergency medical personnel at Good Sam and the medical examiner's findings and sworn testimony, are consistent with bite marks from an animal. They also had attached an affidavit of Dr. Sheridan, who did testify at the first trial. Dr. Irene Squartabello, not a fight. Juliana Nagel, blah, 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 blah. Here. The defendant further suggests that one purported incident with the subject dog occurring several months after the death of Mr. O'Keefe suggests ineluctably, there's a word you don't see often, ineluctably, that the animal was violent and prone to violence. Nothing in the defendant's motion indicates that the animal was actually violent, let alone prone to such violence. Said violence even involved humans, nor that the animal had any interaction whatsoever with Mr. O'Keefe that evening. The defendant further states, without any evidentiary support, that Mr. Albert rehomed the animal after a possibly fictitious report of a skin-piercing incident to hide his evidence of involvement in the death of Mr. O'Keefe and the wide-ranging conspiracy surrounding its cover-up. He goes on to say, furthermore, several of these witnesses barely knew one another prior to this incident, let alone the victim, let alone the defendant they were so actively, purportedly conspiring to frame. And then in a surprise decision, see, this is dated May 3rd, 2023. In what we can only say is a surprise decision because we know this judge, she actually allowed it. She allowed them to get the Canton Town animal control records. But that's what kind of fight it took. And I don't think that the records said where Chloe had been rehomed to, because if you remember Nicole Albert's testimony, you also remember the surprise when she said, "Oh, I know exactly where Chloe is in case it would ever be needed for something." In a 5-page decision, docket number 79, Judge Canoni allowed the defense to obtain the animal control records. Shocking, I know. This is interesting. She says in her decision, that her decision was dated May 19th of 2023. Albert testified before the grand jury that on the night of the incident, his dog was either inside his house or in the fenced-in backyard. He also testified that his dog is not great with strangers and not allowed in his front yard. The Canton town clerk informed a defense investigator that a dog license issued for a 4-year-old German Shepherd associated with Albert's residence in 2019, and that the dog was rehomed to Vermont in May of 2022. So that would mean Chloe was born in 2015, which would mean that now Chloe is 10. Canton Animal Control Officer subsequently told the investigator that she wrote a quarantine order for the dog after a purported skin piercing incident in May of 2022, and that Albert later rehomed the dog. Yeah. Right around the time that grand jury was convened to upgrade Karen Reed's charges. That was May of 2022. That's when the defense team was first provided with the autopsy photos, I believe, of John O'Keefe's arm. Yes. Both the clerk's office and animal control refused to release the related records without a court order. So the defense wants all the records from 2015 to present, and the judge actually gave it to them. Because she thinks they're relevant. 2015 is not too far back because that's when the dog was a puppy. It is reasonable, she says it's reasonable to expect that the records contain further details regarding the reported attack by Albert's dog and the dog's rehoming, likely to include the identity of witnesses with knowledge of these incidents and the dog's current whereabouts. But I don't think it had the dog's current whereabouts in it because that was a surprise when Nicole said that, right? Furthermore, upon locating the dog, the defendant intends to pursue a comparative DNA analysis of samples from the dog and O'Keefe's wounds. Well, no samples from the wounds were ever taken, were they? No, they weren't. She ruled on that May 19th of 2023. And that, my friends, is why Brennan is so afraid of dog bites. Back to the chat. Norman said Jen told 911 he was in bad shape and was bleeding from the face, yet she had not gotten out of the car to see him. That's odd. Lots of odd things happening around Jen McCabe, just saying. Thanks, Norman. Irony in the land of the lost. It is the land of the lost. Chaka is our mascot for this trial. I'd love to hear you say my name. It's my name. It's my name. It's my name, Hank. Irony in the land of the lost. Thank you so much for your super chat. Hannah says Brennan will realize that he can't change the case facts despite his fake righteous indignation towards the defense. The jury will find his antics annoying. I agree. I 100% agree with you. Brennan's lack of judgment is here. 3/4 of this is irrelevant to opposing defendant obtaining Chloe's records, right? But they wanted to get the narrative out there because this is around the time when Marcy started getting wind of the feds poking around. In May of 2023, started writing those letters, ramping up. Jules from Australia, free Karen Reed cupcakes and skullduggery. Stay healthy and hydrate. I know. I'm losing my voice already, and we have not even started this insanity yet. Hannah says the prosecution's witnesses, selective laser vision, butt dials galore, but nobody saw a 200-pound man on the lawn when they left. I know. It's crazy. It's crazy, right? Guys, tell me in the comments what you want to talk about tomorrow because we have a full day tomorrow because the trial's not starting until Tuesday. So we have things to catch up on. Those of you who are new to the case, maybe there's some stuff you want to rewatch. Maybe there's some stuff you want to go over before the trial starts. Let me know because I'm here for you. No Shrinking Violet is here. I don't understand why placing Hibbington's Jeep there is so important. I don't either. I don't think it was ever there, but I can't figure out why. What say you? I don't know. For some reason, I don't know. There's been a lot of theories about it on you go on Reddit really or Twitter, but you can find them there. I'm sure someone in the chat can help you. There's been some theories lately. I don't know. Thank you for your super chat. Carl Johnson, is it possible between the testimonies of Jen, Brian Albert, Brian Higgins that they told each other what they didn't say on the stand and what questions were asked? Everything's possible. Everything is possible except for I think Matt McCabe testified right before Jen McCabe, and so they probably didn't have any time. But, they had watch parties, allegedly, at the VFW hall, so who knows what? They're not supposed to. But I can't say for sure. My nurse Cal, such great friends, let everybody drink and drive. Yeah, wonderful, right? Thanks for your super chat. In Lemonade Pickets, I hadn't noticed until today the intentional obfuscation by using Ms. instead of Mrs. Why would Jen McCabe use Ms.? There are two Ms. McCabes. One is a Mrs. Well, it was Lally who wrote that, right? And whoever wrote her statement, Proctor, she gave a couple statements authored by a couple of different people. So those are Lally's choice of words. But yeah, interesting. ShamWow. Can I please get an unaltered video or photo so I can show my guilt? I've tried so hard. Thank you, ShamWow. Strong legs. Remember 911 call? Jen said they're flipping him over. Yeah, she said we just flipped him over, or they just flipped him over. And I don't know if that means that from stomach to back, or flipped him over to he had vomit in his mouth. I don't know. Nobody was ever asked. Great point. On top, thanks via Super Sicka. And Amara says, I thought Chloe bit someone that was breaking up a dog fight happened before O'Keefe's death. Well, the one that you're talking about was in May of 2022. That's the one they refer to here. But they did uncover a witness who had been bit by Chloe prior to January of 2022. That person is also on the witness list, as is, I think, her ex-husband. I think she received medical treatment, and I believe that she was actually bitten by Chloe. It wasn't a dog attack. It wasn't dog on dog. It was Chloe on human, right? Correct. Thank you. Oh, thank you, Tim, for your super generous Venmo. Says, cheers to Sunday, Easter fun day, living vicariously through the snark tank and actually catching a live for once. Thank you for your dedication to this case. Oh, and for introducing me to Kathy, gossip, rumor, and innuendo. Kathy's amazing. She doesn't do the Karen Reed case. She doesn't do it because she doesn't want to get caught up in the hatred and vitriol. And really, who could blame her? It's unfortunate. But she's like, yeah, ain't nobody got time for that. You know who's got time for that? Nobody. She sees what goes on with people that cover the Karen Reed case, like such as me. And she's just like, hell to the no, not doing it. All right, I'm going to teleport all of you over to the amazing stream of Nurse Kim because Mark Betterow is on there. So thank you all so much for being here with me. According to Woo, thanks, says Mel. We're going to get you at 100K during this trial. Hit that subscribe button. Thanks for always hosting. LFG. And Mama She is here. And she says, happy Easter cupcake fam. Thanks, Mel, for what you do and for all of us and for your hard work. And I love you. I love you guys so much. We'll meet tomorrow. Put in the comments respectfully, nicely. Be nice to each other. Be kind. It is Easter Sunday. It is 420, and it's also the last day of Passover. So let's be nice today. I know you could do it. Stay cool, stay kind, stay classy. Hit the like button on your way out. Thank you to the moderators for keeping it classy. Thanks to all of you for being here with me today. Do a cupcake invasion over on Nurse Kim and Mark Betterow. And I will see you tomorrow. Topic to be determined. But, can't go a day without seeing each other. So happy Easter, my friends. Stay cool, stay kind, stay classy. Peace. Cupcake invasion on Nurse Kim and Betterow in 3, 2, 1. Buckle up, buttercups. Safe travels. I'll see you tomorrow.